Yes. was there. Yesterday, Justice Nath was wishing you.
Yes. No, we miss him every day.
Special bench.
Not only yesterday.
Special bench at 3:30.
Yes,
You have been placed in a category with somebody, you know.
I heard about
You-
it.
Just will share the joke with us too.
Let's not.
he doesn't want to take it any further.
Please. Look, there's a problem in this matter, your lordships have appointed one amicus first. There should have been at least two amicus first.
One for direct and one for properties. three, sorry. The third for the LDC.
One for the High Court, Lords.
For the heck.
Because the High Court's Lords are very reluctant, Lord, to provide data, to speak up what they desire, Lords.
That is the whole difficulty, Mr. Dwivedi.
Yes.
The High Court registry controls everything so strongly. Same as Supreme Court also. Registry is very powerful everywhere. So High Court also, the registry, if they are direct recruits, they will make sure that the promotees don't get their due benefits. And if the promotees are in majority there, they will hold back. That's the whole difficulty.
Because not only the registry, Lord, even the judges, Lords.
I will not talk about judges, but I know definitely for it. They will not provide you the data. They will not place the file at the appropriate time. You keep asking them, file is lost, they are searching, this, that, everything keeps happening. Until you have a very good administrator at the helm.
So there are issues which can be raised factually, constitutionally. They do not, and unless, my Lord, the data, as my Lord Justice Chandran observed, my Lord, unless the data is accurately presented before your lordships, there's a grave danger. There's a grave danger of doing something, my Lord, which may cause serious imbalance rather than arriving at a proper balance. We create a situation that where there is balance already existing, an imbalance creeps in there. So that data, with great respects, is not there. One, my Lord,
The High Courts are before us.
no, High Courts are there, but the data.
You are for the High Court, so you should have placed the data on record.
So
Like,
that's what I started. That has to be an amicus, my Lord, who can pressurize.
This is
my Lord,
like
the
Mr. Chandurkar
courts.
placed the data yesterday.
Yes.
So, in the last so many years.
No, it's not. Your lordships want to lay down a uniform rule.
Yes, therefore, so.
Therefore,
You are appearing for the High Court.
so I'm appearing for one High Court,
You are paying for Allahabad High Court.
Allahabad High Court. I'm not appearing for all the High Courts, my Lords.
There are only three.
And most of the High Courts are not represented, my Lords.
They have been noticed.
No, legally speaking, I'm not saying that adjourn the matter. I'm not saying that.
The High Courts, all the High Courts as well as all the state governments,
But they,
all have been duly served.
I'm saying the data, therefore, is not before your lordship. And whatever data has been picked up, my lords, by the learned amicus, and I must say, my lord, he has faithfully reproduced from the various affidavits. But they are scanty, incomplete, and based on pre-existing, my lord, legal positions. We still don't know, my lords, your lordships have brought.
That's what Justice Vegan said yesterday. Now, these two judgments, the dynamics may change.
Yes.
So therefore, my lords, I stand up, my lords, on behalf of Allahabad High Court to dissuade your lordships from issuing any directions, because it will create imbalance, and High Courts are in the best position. I will show from the learned amicus. And my dissuasion is firstly based on the constitutional plank. That's chapter 6 of part 6, Lord West's exclusive control in matters of appointment, promotion, postings, and control in the High Courts. There may be some situations, I'm not saying that the Supreme Court should keep its hands off completely, Lord. There may be situations, Lord, where a lordship's interventions are required. But generally, Lord, the High Courts are seized with the data and facts, and therefore, they are in a position to deal with the situation which prevails in the High Court in the particular state.
That's the reason, because every high court is taking different stance. The practices adopted in every high court are different. And therefore, some uniformity has to be there. Whatever
There
it is.
cannot be. I'll show from the amicus's affidavit itself. Kindly have that affidavit. Look at the situation, how drastically it is varying. How do you bring about uniformity by a particular? It's not a question whether we should have quota. Next question will be, what should be the quota? Merely saying that there should be some quota is not enough. Where to have the quota? Where not to have? Whether to have? To what extent the quota should be? Should it be 10%, 20%, 50%? So, if the situation is varying, for example, my lord, in West Bengal, as my lord pointed out on the last occasion, there is a fair balance today existing. Now, any quota is bound to disrupt that balance. In Allahabad High Court, the age gap, which was 10 years, in the last 3 years has come down. Lord, is varying between 4 months to 3 years now. Because of the roster system and the holding of the examinations regularly in time and simultaneously every year in recruitment year, it has come down. Now to introduce, Lords, a quota system, A is unnecessary and B can create another balance. Lord, look at the situation. Lord, your Lordships introduced a quota in 2002, 50, 25, 25. In 2010, within 8 years, your Lordship thought, well, people are not coming, therefore 65, 25, 10. Another 10 years, again we say that it should be 50, 25, 25. So within a span of 18 years, 3 uniformities. So let the high courts deal with the situation. This is not that kind of a problem which is uniformly existing in the same manner in every high court. Now see, look at their amicus's affidavit. Written submission, sorry. And your Lordships have made some good changes because in the previous judgment, your Lordships have opened up the direct recruitment also. So therefore, Lord, now the whole 100% field is open, Lord, for the Civil Judge Junior Division to walk into the higher judicial service. If they are keen, if they are intelligent, if they believe in themselves, they should appear at the earliest, Lord, in that examination, directly to examinations, and they will be at par, Lord. But if they are diffident and if they feel that it is better to walk the longer route, as we know, Lord, that if you go to Amarnath, Lord, there are one short route, Lord, which is much more steep and risky, and the other through Pahalgam, Lord, and the other is through Sonmarg, Lord, which is a longer route and less.
Longer route, but reaches the destination.
Yes, you reach the destination. And unfortunately, that's the problem.
Here the difficulty would be if you take other route, you will be lost.
No, here the destination is not selection grade, not super time. Here the Amarnath is the judgeship, my lord, of the High Court. These are not problems. Yesterday's argument, my lord, then I again obtained more data from the Allahabad High Court, and I find that in the selection grade also the promotees are much more than the direct recruits. I'll show that. So selection grade is also not an issue. Issue is the High Court judgeship. Because there, my lord, your lordships have some unwritten rules, what will be the zone of consideration, etc. And your lordship knows better than me, my lords, how, my lord, from the judicial service, They are picked up. If your lordship opens it up to the entire zone of consideration is made the whole of this super time scale or the district judgeship. Every lawyer doesn't become a judge, my lords. That is heartburning. Heart is a very
No, many
fickle.
lawyers refuse to become judge.
Many refuse to become judge, my lords. So maybe there is heartburning also. Why A is selected, why B is not selected, all those keeps on happening, my lords, everywhere. And there is no system of selection, my lord, that a lawyer who is more aged, my lord, he'll be selected, and who is less aged will not be selected. So these kind of heart burnings are normal. Heart is such a fickle thing, my lord, that is very easily burns, my lord. Even if the neighbor, my lord, is having a better car or a better fridge or something, it will burn.
Right.
So we can't take care of heartburns. And rest, your lordship, my lord, since O.P. Garg's case, have been saying, my lord, that now we hope it will come to a rest. It will not rest. Whatever a lordship provides quota, this promotee versus direct recruit will go on. And it lingers, my lord, after becoming judge.
That has been a wishful thinking in many judgments, and still it's like that.
Yes.
It's not, this judgment will not be an end of the country.
Not,
That-
my lord, right?
That both sides should.
Our effort is, my lord, to improve it. That's about all. Whether that improvement
Betterment
becomes, my lord, a deterioration, we don't know.
Well, it's always trial and error.
Therefore, leave it to the High Court, my lords. That's what I'm saying. If it is trial and error, my lord, it's let that authority which is constitutionally constituted, capacitated to do it, my lords. Force them to do it. As in the last case of age, your lordships passed an interim order saying let the High Court first consider whether age should be 61 instead of 60. Why should the High Court be bypassed, my lord? Then why should this be divested of their authority, power, and duty? It's a constitutional duty of the High Court. Not only authority and entitlement, it's a duty, my lords. And it's time to strengthen the High Courts, not to weaken the High Courts. With great respect, my lord, your lordship may condone, my lords, my expressions. But things are gone a little too far. In this very court, a petition was filed, which is still pending. 1 of 2017. In concept note.
In
Concept note. On the basis of some letter from the government, a committee was constituted, and that committee was tasked to determine, my lord, whether this court should hold the selections and create a pool for recruitment to the office of district judge. That was the concept note. And that
the issue with regarding All India Judicial Services on the pattern of IAS and IPS is always alive.
that authority, that's another grave breach of, kindly have a look at, let me complete this story, my lord, first before going to 312 All India Judicial Service, what it is. That committee, headed by Justice Goel, approved that concept note. Amicus was appointed, and the matter was listed in the concept note in the court. So the whole selection will be done by the Supreme Court, and High Courts will now, my lord, just pick up. What remains of Chapter 6, my lord? It's dead.
But we are not inclined to do anything of that sort.
No, it's pending.
No, not even remotely.
After our resistance, the bench was disbanded. After hearing the matter for 2 days, bench of Chief Justice Kehar, Justice Goel, it was disbanded. We said, please, it's a destruction of the High Court. It's an elimination of Chapter 6. Now, my lords, what should be the qualification?
Even if we recommend to the collegium some of the lawyers practicing here, you only suggest the names and leave it to the discretion of the High Court entirely.
But
And
here,
we call upon those candidates, go and argue before the Chief Justice and the Collegium Judges, and only after they find suitable, the names have been recommended even from the lawyers of
that's good. That's very good, Mullards. That's how it
We
should.
thought that
That's
there-
how it should be.
We thought that there has to be some opening to the lawyers practicing here from
Yes.
different states.
Mr. Dwivedi, the instance which you are quoting,
Yes.
I am quite sure that you must be aware that what were the reaction by some of the high courts.
I appeared for the High Court, Mullards, for 3 High Courts.
And I wish if a day comes when you display the online discussion, when the opinion of the High Court was sought, how some of the judges of the High Courts reacted, including me.
Yes.
So if there is an issue, there is a point, if there is a need to take a stand, we do take a stand.
That's right.
And I wish if that is displayed, and what I said.
It should be dismissed. But therefore, I'm saying, Lord, today we are fixing the age of retirement, we are fixing the quota, we are fixing the criteria, we are fixing, Lord, what should be the quota of the various sources, what should be the age with eligibility. Then if you allow that petition also, Lord, concept note petition is still pending. Unfortunately, though it was adjourned, it was tagged with Malik Mazhar and it is still pending. So someday, Lord, somebody may feel, Lord, that it's time now to.
Honorable CJ has already hinted, it's the purpose is not to usurp the power of anyone. That
No,
constitutes.
so but ultimately to introduce whether your lordship weightage or quota, that's the two broad suggestions. Your lordship will have to issue a mandamus, Lords. And mandamus for what? To make a legislation. The rule of the High Court is legislation at par with parliaments and state legislatures' law, Lords. It's not a subordinate legislation. In some cases, they refer to it as subordinate. It's not subordinate. So you will have to issue a mandamus.
It will be only, so as already hinted, for uniform guidelines, for a kind of an infusement of the strength and for betterment of the. Not
Betterment and enhancing the efficiency, that's the only.
So what will the High Court do? High Court has to
Suppose-
follow it.
Suppose even.
And High Court can't amend it.
We don't know what we are going to do.
No, I'm
No,
dissuading.
if we accept any of the suggestions given by the learned amicus, even if quota is provided, it's not necessarily go by seniority.
No, I'm not on what your lordship will do. I'm
We are-
trying to dissuade your lordship.
We also don't know what we are going to do. That's what we are saying. But even if we do something of that sort, we will not be taking away the discretion of the High Court in recommending the names.
No, if
Names
the-
would be recommended
if-
by the High Court solely on the basis of their satisfaction with regard to the suitability of a candidate to be elevated.
if the discretion is of the High Court is not to be taken away, leave it to the High Court.
But why are you averse to having some uniform policy throughout the country?
No,
Why
uniformity.
should there be some different policy in the Bombay High Court and something?
Because in all aspects, with great respects, in all aspects, there cannot be uniformity, and uniformity
There can't be
is the wrong goal to say.
100% uniformity. Aren't there promoted judges in the every High Court? Aren't there direct district judges in the every High Court? Is there any distinction that say Madras High Court, 50% are direct district judges and 50% are promoted? When there is a uniformity in all that aspect,
So uniformity in this matter, my
and
lord,
rest assured, we do not even indirectly, remotely intend to take away the discretion of the High Court.
my lord, uniformity in this respect, my lord, will be disastrous.
Mr. Dwivedi, you also please keep in,
Yes.
we are quite sure you are aware, some of the judgments have been cited. This court has already intermittently and in one or the 2, 3, 4, 5, 7 high courts, on the criteria or formulation of seniority has already interfered, leaving no scope for the high courts, leaving no scope for the discretion of the high courts. The full court decisions of the high court have been set aside here. And if a particular way of directions have been issued, in some of the cases, even ignoring the statutory rules, what to do? Are we not required to, in sitting in larger benches,
So
to
if-
rectify our own
Well,
mistakes?
once the High Court makes a rule, if your lordship and matter comes before lordships in a appeal, my lord, the lordship certainly can issue directions. But today, my lord, here is an IA moved by an amicus seeking a direction to protect the promotees.
That's only everybody is giving their viewpoint. It's not that necessarily that we will follow that. way.
But this methodology, my lords, I'm with great
It's only
respect.
evaluation of the best of the possibilities that what can be.
Well, it's my humble submission, my lords, the lordships.
All right,
We record that
Because
we've
it's,
taken note of the submission,
Yes,
that
yes.
we need not do anything. All right.
Yes.
Now you proceed whatever you wish to say on the submission.
On the submissions made on the other side, including Vakeja's, that there has to be a separate court of our LCD for elevation.
the lordship will take note, do whatever a lordship feels, my lord. I'm trying to I said,
No, we have recorded your submission. We have recorded your submission, as Justice
Yeah.
Raj has rightly pointed out. We should adopt the practice of hands-off.
A, hands off, and B, my lords, even if your lordship has to issue some guidelines or directions, it should be general, so that High Court's
How
discretion.
many times have we been telling you that we don't even remotely intend to take away
Yes.
any discretion vested in the High Court?
That's my humble
That's
submission.
all right. It's only going to be a general direction. There is nothing like that intersectionality. We have already indicated to the other side also. There is no question of entertaining intersectionality dispute by us.
Now kindly have, my lords, the second plank, my lord, for dissuasion is the great divergence. So, amicus का note, amicus का note. Oh, नहीं, amicus नहीं. ये amicus. Which page?
23.
Come to paragraph 23. Kindly come to paragraph 23, my lords. Amicus written statement.
Yes.
Paragraph 23.
Yes.
Yes, the chart.
Now kindly see, my lord, different states. What is the age gap difference? Andhra, Chhattisgarh, my lord, happens to be on the higher side. Gujarat is somewhere in the middle. Now see Haryana, only 2. This is not something abnormal, my lords. 2 years gap. Kerala is 4, Madhya Pradesh is 2. Next page,
Rajasthan 42 against 13.
yes. Barring the first 2, the rests are between 2 to 6. And if your lordship comes to Sikkim and Uttarakhand,
Yes, reverse.
reverse.
Sikkim, what was the strength of judiciary?
Now kindly have a look at paragraph 27. However, the situation is quite different in several other states, where promotee district judges are much more in number than direct recruit district judges at the post of principal district and session judge, district judge super time scale, as is evident from the following. In state of Chhattisgarh, as per the seniority gradation list of the cadre of district judges, out of 23 principal district session judge, 14 are promoted district judges. In state of Gujarat, as per seniority gradation list, out of 33, 24 are promoted. So whole list of high courts, which runs through at least 12 high courts, include 13 high courts, including state of West Bengal, which is at K, and Tamil Nadu is H. Delhi High Court is there. So where is the need, my lord, for?
Even for uniformity.
No,
It
there's-
will also be in the interest of the direct.
No,
recruits
this
where-
will-
where-
this-
where their position is.
No, this will keep on varying. It's not a question that this is a data based on the pre-existing rules. Now with your lordships opening the doors of direct recruit, many of these promotees will get an opportunity to.
If the dynamics change, the law will change. Where four of us would not be here.
That's not the point, my lord. To us, your lordships are lordships. My lord. We don't look at the faces.
You also don't, in the latter way.
Your lordship will have to look at the faces.
2010 changes.
For us, your lordships are all judges, my lord. So it
2010
doesn't matter who is there.
2010 changes, 2002 changes in 2010, depending upon the circumstances existing there.
What?
25, 24, 25, many of the high courts feel that the changes made in 25, in 2010 need to be relooked into.
No, therefore let them, therefore I'm saying that such is the variance that therefore there should be no uniform guideline, my lord, directed to the high courts because there is
On
so
the
much of
contrary,
variance. Leave it to the,
if this variance is removed,
it
will-
cannot.
it will balance the rights of all the stakeholders.
It's because, my lord, there is lot of other factors in play. Let me come to the other factor based on what is happening with us.
I'm sorry to interrupt, my friend. Para 25 goes one way, para 27 goes the other way. So there's a whole set of states in para 25 where the district direct recruits are more. Para 27 is what my
Where
friend
the
said.
promotees are.
So there's no uniformity there in
That's
any.
that's what we are saying.
Whichever way you correct it, it's very difficult to create.
After 7, 8 years, you are right, the dynamics will change. Now with the 3 years practice at the bar, joining the service, judicial service, as rightly pointed out, part of eligibility for direct recruitment. So after 7, 8 years, the judicial officers will be eligible to compete not only for 25% LDC, but for 25% direct recruitment also. So there can be a possibility that suppose you have a cadre of 100 officers, junior division, out of them, 25 are selected in LDC, 25% are selected in direct, hypothetically, and only 50% are left.
But laws,
So the
I appreciate.
it's completely a new dynamics for
So-
interest seniority
No,
determination.
so,
We are right.
The latest judgment of 25, your lordships have proved the concept of LDC even at that level. So that will further give a fitting to the writer of the, I'm sorry. I apologize.
The impact of it will be only after 7, 8, maybe 10 years that somebody will be able to
You
evaluate.
will not be there. All of you will be there after 7, 8 years and again, take up that issue.
No, I'm,
Get it modified.
no, there's something much more than this.
Yes.
Look at the various other factors. Your lordship may have quota if your lordship wants, put weightage, whatever.
We are telling you, we don't know what we are going to decide.
No, I'm saying,
Therefore,
what,
at the threshold, one argument we have obviously we understood. So you tell us what are your oppositions to the submissions made by.
I'm-
So that we can consider. You tell us what are your oppositions.
no,
to
no,
the
I'm not,
submissions.
I'm not
So that we can
proposing
consider
anything. I'm
we are
saying
going to
don't
decide
do
what
anything.
the other- that's
I'm
what- that-
I'm
that-
not
that-
proposing
that-
anything.
I have-
I'm saying don't
No,
do
it's not.
anything.
That- that's all.
Saying if say
That's
Dixie
all.
that I say
No,
don't
I
do.
have
Why you
No,
should
it's
not
not
do it?
simply
That's
by
the
saying if
reasons
Dixie
I'm
blood
that
that
I
I
say
say
don't do. Why you should not do it? That's the reasons I'm. There are
Look at the
various.
factors now.
So now
Comparison.
there are various.
Comparison में क्या करें?
There are
tells that for applying the doctrine
there are
of facts of-
various imponderable
for applying
factors
the doctrine of facts
which
of-
operate, my lords, imponderable factors in determining whether there should be a quota weightage or not, determining whether there should be a quota weightage or not to the High Court. Neither of them, the various factors. As it is. First is, my lord, why is there this age gap? The various factors. First is, my lord, why is there this age gap? None of the petitions affidavits are throwing any light as to why, my lord, the petitions affidavits are throwing any light civil divisions as to why, my lord, civil judge junior the judicial officers in the civil are reaching late, my lords. Civil judge junior division are reaching late, my lords. If a lawyer gets an LLB degree at 22 or 23, gets an LLB degree at 22 or 23. Before your lordship's judgment, there was no bar, my lords, in appearing. Before your lordship's judgment, there was no bar, my lords, in appearing for the junior division examinations. But lawyers were not appearing at junior division. The average age lawyers were not appearing at 26. The average in the examination is the most important factor, my lord, appearing in the examination. In Allahabad High Court, it is the most important factor, my lord, which get. Now, please get this data. In Allahabad High Court, it is 28. This is very important. Now, please get this data from all the high courts. Crying about the age gap, increasing very important. Age gap, even Shetty Commission emphasizes. All crying about the age gap, the reason is age gap, even Shetty Commission that lawyers are appearing in this examination at a late stage. That lawyers are appearing in this examination at a late stage. Your lordships have not barred the door. I have a choice. It's their choice to carry on with my practice. I have a choice to refuse judgeship. To carry on with my practice. I have a choice to appear. I have a choice to refuse examination upon reaching. I have 35 years to appear and go straight to 7 years examination. And I have a choice 35 years and go straight to earliest at the lowest rung. And I have a choice to go at the earliest at the lowest rung. An individual lawyer is exercising his choice. So an individual lawyer is exercising the age of 30 and 32. And if I exercise my choice at the age of 30 and 32, and I'm bound to the examination experience in the Allahabad High Court is, and the average examination experience in the Allahabad High Court is, that the average age is 28 years. We have mentioned in our affidavit, if your lordship has that affidavit. Volume 3 R1.
This is volume 3 R1, page 1.
Volume 3 R1. कहाँ हमारा affidavit? कहाँ हमारा affidavit? Now, if average age is 28, which shows, my lord, that the large number of people are appearing in the examinations beyond the age of 30 years. The large number of people are appearing in the examinations beyond the age of 30 years. From different high courts. And none of the promotees are giving the average age data, my lord, from different high courts. If I appear, choose to appear at the age of 35 and become a munsif, my lord, and then I complain, my lord, that I appear at the age of 35 and become a munsif, my lord, and then I complain, my lord, that I don't get a fast track. These are the problems which are existing there, my lord, and these facts are not before your lordships. The problems which are existing there, my lord, solution the lordships are not before your lordships. In the absence of whatever material data. Solution the lordship will find will be in the absence of material data. Kindly have paragraph 7 of my affidavit. Kindly have paragraph 7 of my affidavit. And now your lordships have put a 3 years bar of experience. And now your lordships have put a 3 years bar of experience. Appear naturally, my lord, at a later stage. So they will, that's a further appear naturally, my lord, at a later stage. That's a further. Now in the interest of efficiency of service, my lords have rightly put. Now in the interest of efficiency of service, my lords have, it's not a question of a difference of age. So therefore, between the two groups, it's not a question of who is reaching and who is more or who is less. Gap between the two groups and who is reaching and who is more or who is less. Of the judicial you have to keep in mind. That's the most important thing. Efficiency. That's why, Lord, this 3 years bar has been put. That's the most important thing. Consequence. And that's why, Lord, this 3 years bar has been put. Notwithstanding the consequence being. However, even if 3 years is taken to 23 to 3, 26 and 26. However, even if 3 years is taken to 23 to 3, 26 and 26. So they complete 7 years also for directly appearing. So they complete 7 years
who
also for
prevents not
directly
this judicial
appearing?
officers now that your lordships have opened the door, they should
So who
complete,
prevents
my lord,
not
then
this
whoever
judicial
is
officers now that
confident
your
about
lordships have
himself, he
opened
will
the
come,
door,
my
they
lord,
should
then the
complete,
direct
my lord,
recruit.
then whoever is
Your lordship will find that
confident
half
about
of the
himself,
direct
he will come,
recruits
my
will
lord,
be,
then
my lord,
the direct
the-
recruit.
your lordship will find that half of the direct recruits will be, my lord,
So let us see the fallout of what your lordships have already provided.
They would not be
So
promoted.
let
they would
us
be
see the
appointed.
fallout of what your
How
lordships
would
have
they be
already
promoted?
provided.
They would not be promoted,
No,
they would be appointed. If they are selected, how would they be promoted? If they are selected, they will be direct
No,
recruit. If they are
no,
selected, they will be promoting.
No,
If they are
from
selected,
their
they will be
group,
direct recruit.
from their
They will
group,
be promoting.
I'm
no,
not,
from
they
their
are
group,
from the judicial,
It's
from
not
their
as if
group,
that their
I'm
initial
not,
service will be
they
counted
are
and
from the
they will get a
judicial.
retrospective. As if that
No,
their
I'm
initial
saying
service will be counted and
And of
they will
course,
get a
of
retrospective.
course it
or
will be
something.
fresh, but
No,
the
I'm saying it will be a
the
fresh
civil
appointment.
judge junior division,
of course,
by
it will be
this
fresh,
route,
but the
the
faster
civil
into the
judge
district
junior
judge.
division,
That's the important
by
thing.
this route comes faster into the district judge.
That's
So
the
therefore,
important
this
thing.
permutation and combination which your lordships have now produced. So therefore, this permutation
see,
and
Lord,
combination which your
we are,
lordships
Lord,
have now
sort of
produced.
Yes.
Let us see, Lord, moving ahead.
we are,
Another sort of
Yes. So, Dwivedi, what is the next point?
hastily, Lord, moving
So,
ahead.
Lordship
Lordship may
may
kindly
kindly
note, Lord, I have
Mr. Dwivedi, what is
indicated
the
at
next point?
paragraph 7. So Lordship may kindly note
The
Lord,
minimum
I have
age,
indicated at
28.
paragraph 7.
The minimum
Now,
age, 28.
there is a small note, my Lord, which I have prepared. There is a
If the
small
lordship has that note,
my Lord, which I have
allows me to
prepared.
place it.
If the Lordship has that note, allows me to place it.
Similar for example, for examination. Similar for example, for examination.
What is it called? What is it called? The mouse. The mouse.
May I quickly just take your Lordship through this note, my Lord, just a small note. May I quickly just take your Lordship through this note, my Lord, just a small note. The submissions of the learned amicus are founded on the factual premise of increasing
The submissions
age gap
of the
between
learned
the
amicus
direct
are
recruits
founded
and
on the
promotees
factual
in the
premise of
HAS cadre.
increasing age gap
As
between
per
the
para
direct
23
recruits
of
and
his note,
promotees
it
in the
appears that
HAS
there is no
cadre.
uniformity
As per
regards
para
age gap in
23 of
different
his note,
states.
it appears that
In
there
West
is no
Bengal,
uniformity
Chhattisgarh, and
as
Madhya
regards
Pradesh,
age
there is
gap in
broad
different
equivalence
states.
between the two
In West
categories.
Bengal, Chhattisgarh, and
And
Madhya
in
Pradesh,
Sikkim
there
and
is broad
Uttarakhand, the
equivalence
promotees
between
are
the two
younger in age.
categories.
In And in Haryana and Sikkim Madhya and Pradesh, the Uttarakhand, gap the is promotees are negligible younger 2 in years. age. Even In in Haryana and Madhya Pradesh, the gap is negligible 2 years. Further, in Even para in 27, Jharkhand it and is Kerala, pointed the out gap that is there is only not 5 much years. difference in the Further, average in age para of promotees 27, and it is direct pointed recruits. out that there is not Reverting much to the difference in additional the average affidavit age of of the Allahabad promotees High and Court direct dated recruits. 25, Reverting to the 10, additional 25, affidavit it of could the appear Allahabad High that from Court the year dated 2012 onwards, the age gap has come could down appear that drastically from the year 10 years to between 2012 4 months in onwards, 3 the years. age gap has come down drastically There from is some 10 years to variation on between 4 account of months in different 3 years. factors. One of the factors for the There is some relatively higher variation age on for the account of different recruitment factors. of One of HJS the is that factors for the several of the relatively candidates higher appear in age the for the civil junior recruitment of division HJS examinations is when that they are several of the 28 candidates years of appear age in the or civil above. junior division examinations when they Ordinarily, are a lawyer 28 would be years of eligible age to or appear in the above. examination at the age of 22, Ordinarily, a 23 lawyer years, would as be earlier eligible to appear there was in the no examination limitation at of the 3 age of years. 22, Practice at the 23 bar years, for as appearing in the earlier there examination. was no limitation Even of after 3 the years. stipulation of Practice at 3 the years bar for practice appearing in the requirements, they will be examination. eligible to appear Even in after the the age of stipulation of 25 25 practice 26 requirements, they will be ordinarily eligible to the appear civil in judge the age of junior division takes takes 10 to 12 years of service. Ordinarily, before the being civil judge considered for promotion junior to division HJS. takes 10 to 12 Since years the of minimum service age for before being HJS is considered for 35 years, promotion to normally there HJS. should Since not the be minimum age occasion for for HJS is substantial 35 age years, gap normally between the there two should categories. Not in be para occasion 7 of for the High Court substantial affidavit, age it has gap been between the stated two that the year categories. 2022, In para 7 of the High Court the average affidavit, age it has of been selected stated that the year civil 2022, junior division was the average 28 age years. of This selected indicates candidates for that a civil sizable judge number of junior candidates division were was above 28 30 years. This 30 indicates years. That a sizable number of candidates in were para above 9 of 30 the aforesaid 30 years. affidavit, a chart is included which shows In para 9 that of from the the year aforesaid affidavit, 2008 a to chart is 25, the included, which promotees shows are occupying that from the year 75% or more of the post in the 2008 to JS 25, the cadre. promotees are occupying So far as the post of 75% district or judge more of the post in the stroke JS the equivalent
cadre.
posts are concerned,
So far
it
as
is
the post
stated
of
that
district
there are in
judge
all 268
stroke
posts.
equivalent posts are
Of which
concerned, it is
75
stated
posts.
that there are in all 268
In
posts.
75 districts
Of
are of
which
district judge.
75 posts.
The rest are equivalent posts.
In
Out
75
of
districts are of
268 posts at present,
The
there
rest
are
are equivalent
103
posts.
direct
Out of
recruits.
268
And
posts at
148
present,
are
there are
promoting
103
officers.
direct recruits.
And
At present, there are
148
70
promoting
district judges, of
officers.
which 12 are promoting officers.
At present, there are
According to the
70
information
district judges,
obtained
of
from
which
the
12
High
are
Court on
promoting
28,
officers.
12, 25.
According to the
There are
information obtained from the High Court on
233
28,
selection grade,
25, which
there are
constitutes 35%
as
as
per
per
Rule
Rule 27
selection
of the
grade,
UPSJS
which
rules.
constitutes
Out of
35%
these
as per Rule
233 posts,
27 of the
only 34 are
UPSJS
direct
rules.
Out
Recruit
of these
officers and
233 posts,
198 are
only
promoting
34 are
officers.
direct recruit
So
officers.
even in the
and
selection grade,
198 are
they are in
promoting
large
officers.
numbers.
So even in the
Much
selection
larger
grade, they are in
than the
large
direct
numbers.
recruits. Much larger than the direct recruits.
Out of these 233 posts, only 34 are direct recruits and
Out of
198
these
are promoting
233 posts,
officers.
only
One
34
officer
are
is from
direct
LCD
recruits
and
there are
198 are promoting
78 posts of
officers.
district
One
judge
officer is from
super-time pay
LCD.
scale. Out of these,
There are
65
65
are
are
direct
direct
recruits
recruits
and
and
12
12
are
are
super-time
promoting
pay
officers.
scale. Out of these,
The letter from the
65
High
are
Court
direct
is enclosed
recruits and
and
12 are
I have a
promoting
next one.
officers.
Yesterday I got this
The letter
information.
from the
which
High
is
Court
at the
is
end
enclosed
of this
I
note.
have a next one. Yesterday I got this information.
Apparently, the
which is at
situation
end
is not at all
of this
alarming
note.
as has been projected. Moreover,
Apparently, the situation is not at all
configuration at
alarming as
different
has been
levels
projected.
Levels is a fluctuating phenomena and would vary
configuration
from
at
time to
different
time.
time.
The levels is a fluctuating phenomena
Para
and would vary
16th
from
of the
time to time.
additional affidavit,
It has been stated
Para
that since
16th
the
of
year
the
1990, a total of
additional
200
affidavit, it has been
officers from
stated that since
SJS
the year
have been
1990, a
elevated
total
to
of
the High Court.
200 officers
Out
from
of these,
SJS
133 officers
have
were
been
promoted
elevated
to
and
the High Court.
67 were direct
Out
recruits.
of these, 133 officers were promoted. Considering
and
the elevation
67
at
were
different
direct
points
recruits.
of time, it is apparent that from the chart that
Considering
up till
the
the year
elevation at different
2009,
points
the
of time, it
promotees
is
elevated
apparent
in
that
the
from the
judge of
chart
High
that
Court
up till
were
the year
far more than the
2009,
direct
the
recruits.
promotees elevated in the judge of High Court were
Between
far more than the
2010 and
direct recruits.
2019, 32 direct recruits were elevated.
Between
and while to
2010 and
27 promotees
2019,
had been
32
elevated.
direct recruits
So
were
almost a fair
elevated, and
balance.
while to 27 promotees
After
had been
219,
elevated.
the
So
promoting
almost a fair
officers
balance.
is 11, while the direct recruits
After
are 26.
219, the
The
promoting
fluctuation
officers
is on account of
11,
more
while
than
the
one
direct
reasons
recruits
for
are
which is happening.
26.
So
The
when a
fluctuation
crop
is
of
on
younger
account of
civil
more than
judge
one
divisions
reasons
are
for
there,
which is
my lord.
happening.
So
They will
when a
remain and
crop
get
of
a
younger
longer
civil
term,
judge division
but
are
if
there,
a-
my
You
lord.
must also keep in
They will
mind that
remain
the
and
direct
get a
recruits
longer
quota
term,
is much
but if
bigger than the direct. Keep in mind that the direct recruits quota is much bigger than the direct. And see the numbers. Promotees
So
quota is much bigger than the direct.
Therefore, I said in the beginning, my lord, the target is that. Then therefore, I said in the beginning, my lord,
there, my lord, that some
target is
internally some
that,
changes should be
then
there, so that
it
the
is
whole
there,
of
my
this
lord,
is
that
some internally some
Actually,
changes
to be
should be
examined
there,
whether or not
so
to
that
do
the
anything.
whole of this
Yes,
is.
that is actually
But
to
that
be
has been
examined whether or
prevailing
not
since
to do
long.
anything.
Yeah.
Yes.
That's up to, my lord.
But
That's
that
not
has
the
been
issue, my
prevailing
lord,
since
before your
long.
lordship. That's entirely within your lordship's
That's up to
domain, my
my
lord,
lord.
what to
That's
do or
not the
not to
issue,
do.
my lord.
Before your lordship, that's entirely within your lordship's
Yes.
domain, my lord, what to do or not to do.
It is submitted that
According to the written submission of the learned amicus, in several
It is
states, the
submitted that
promotees are much
according to
more
the
than
written
direct
submission of
recruits
the
at the
learned
post of
amicus, in
principal
several
district
states,
judge,
the promotees
district
are
judge,
much more
super
than
time, see
direct
para
recruits at the
27,
post of
states
principal
mentioned are
district
so and
judge,
so.
district judge,
There
super
is no
time, see para
similarity in the
27.
position of different
States
states in
mentioned are
most
so and
states.
so.
Either
There is no similarity in the position of
promoting
different states
officers
in
are
most
larger
states.
in number.
Either
This
there
is
exists a
apart
broad
from the
equivalence
fact
or the
that
promoting
the
officers are
numerical
larger in number. This is
interrelationship,
apart from the
is
fact
of a
that the
dynamic
numerical
nature
interrelationship
and is variable.
is of
Therefore,
a
the prayer
dynamic
sought
nature
for ought not to be
and
accepted,
is variable.
and the matter should be
Therefore,
left to
the
the High
prayer
Court to
sought
tackle
for ought
any
not to be
imbalance which may
accepted,
exist.
and the matter should
Now,
be
my lord, I
left
may
to the
just
High Court
inform
to
your lordship,
tackle
lord,
any
that
imbalance which may exist.
it has also
Now, my lord,
happened
I
in
may
the
just
Allahabad High
inform your
Court,
lordship,
and my
lord,
lord
that
Justice Nath must be it knowing has that also happened in the Allahabad
that
High Court, and my lord
sometimes,
Justice
my lord, there
Nath
are
must be knowing
vacancies
that
in the
civil
sometimes,
judge senior
my lord,
division
there are
level.
vacancies in the
And
enough
civil
candidates
judge
are not
senior
available
division level
because of the eligibility
and
requirement.
enough candidates are
So the
not
High Court
available
has been granting
because of the
relaxations,
eligibility
Lord.
requirement.
So the High Court has been
So it's
granting
not that the High
relaxations,
Court is
Lord.
not closed its eyes and doing
So
nothing.
it's not that the High
So
Court
whenever
is not
the situation
closed
requires
its
in the
eyes and
interest
doing
of
nothing,
judicial
So
efficiency,
whenever
administrative
situation
efficiency,
requires in the
the
interest
High
of
Courts have been
been, my
judicial
lord,
efficiency,
alive to the
administrative
situation.
efficiency.
The time that
The
is
high courts have been, my lord,
because of the
alive to the
jurisdictional,
situation.
like time that we have monetary suit, or even in
We don't have the
criminal
specific
track,
number
like
of
we
minimum
have monetary
officers
suit,
for to be placed in
or
every
even
district.
in
We don't have the
criminal
specific
track,
number of
that
minimum
relaxation is
officers
always in
for to
public
be placed in every
interest.
Yes.
district.
That is done. So that relaxation is always in public interest.
Yes.
That is done.
I have mentioned about it.
Many high
I have
courts
quoted your lordship's orders.
I have
mentioned about I'm not reading them decent judgments. Your lordship's
And my plea is, my lords,
I'm not reading
that
them
please wait
decent
and watch
judgments.
and
And
see,
my
my lords,
plea is, my
what
lords,
is the fallout
that
of these
please wait and
judgments.
watch
And see,
See,
my
my
lords,
lords, in a
what is
year
the
or 2 years
fallout of
time,
these
my lords,
judgments.
we'll have
fresh people in a year or 2 years time,
What is the fallout? What is the imbalance?
Yes,
Fresh
that is
but
what-
exact equality,
This is the fallout.
that is
What is
already
the
been
imbalance?
argued. Yes,
exact,
that
but
is
exact equality,
Pardon
that
me
is
for
already been
repetition.
argued. This was
Exact.
the 8th or 10th time that you are arguing the same
Pardon
point.
me for repetition.
This was
The
the
point
8th or
is-
10th time that you are hammering the same point. If you do it 12 times, then it will have more impact. That if you
We don't know, Manoj,
do it
what
12
will
times,
have
then it
impact.
will have more
That's,
impact.
we argue in a
we
state
don't
of
know, Manoj, what will
uncertainty,
have
because
impact.
not
Well,
knowing
that's-
what is impact.
we
argue in a
Correct.
state of uncertainty,
Therefore,
because
your
not
lordships,
knowing what is impact.
Correct.
And Manoj, so far as
Therefore, your lordships,
the position of the Allahabad High Court,
and Manoj, so far
something
as
was said by two learned
the
counsels,
position
Manoj,
of the Allahabad High Court, that
something was said by
the
two learned counsels,
promotees
Manoj,
and the direct recruits
are not being
promotees
recruited in the
and
same
the direct
recruitment
recruits
year,
are not
and if
being the
promotees
promotees in
are
the same
recruited in
recruitment year
A and
if
year
the
one, and
promotees
the
are
direct
recruited
recruits in year
year
two,
A
so
and
they
year
can't
one
then
and
be
the
put in
direct
through the
recruits in
roster
year
system
two, so-
above.
But
They
that's
can't
not
then
the
be
position after
put in through the
2012.
roster system
Earlier,
above.
Manoj, there was a
But
problem.
that's not the position.
Number of
After
litigations which
2012.
came up to this
Earlier,
court,
Manoj,
Manoj, there
where
was a
vacancy
problem.
determination
Number
and
of
other
litigations which
aspects,
came up to this
promotees
court,
versus
Manoj,
direct
where
recruits,
vacancy
because of which,
determination
Manoj,
and other
recruitments were held up.
promotees versus direct recruits.
But
Because
after
of which, Manoj, the
2012, recruitments were held up.
every recruitment,
But after
the
2012,
recruitment year is same. Every recruitment, the recruitment year is
advertisement
same. Manoj, for selections and appointments and all the three grades are being
advertisement,
issued
Manoj,
simultaneously. Selections
the
and
letters of
appointments and all the
appointment
three grades are being issued
simultaneously. The
So
letters
it's
of
not a
appointment
case
are
where,
being
Manoj, there is a
issued
different
simultaneously.
recruitment year. So I agree, Manoj,
So
that
it's not
there
a
should be
case
the
where,
same
Manoj, there is a
recruitment year,
different
at least in
recruitment
year. So
this
I
court-
agree, Manoj, that
I don't
there
know
should
about
be the
Bihar,
same recruitment year,
but
at
in
least in
Allahabad
my
High Court,
this
Manoj,
court,
this is happening.
I don't know about
And
Bihar.
in fact, in the previous
But
year,
in Allahabad High Court,
when
when
this
we
is
sent
happening,
the
and in fact,
notification
in the
to the
previous
state
year,
government, they issued for the
when we
direct
sent
recruit
the
first, we
send it
notification
back
to
to
the
them, no,
state
all
government,
three
they
should
issued
be
for the
shoot
direct recruit
simultaneously.
first. We
So all those
send it
issues,
back
Lord,
to them,
don't
no, all
arise,
three
it
should be
shoot simultaneously.
Mayuri
So all
Milords
those
and
issues, Lord, don't arise,
Dinesh
it should,
Trivedi,
they were pressing about
Mayuri Milords
the
and
roster being
Dinesh
same.
Trivedi,
So,
they
so
were
they were pressing about
So you
the
agree with
roster
Mr. Dinesh Trivedi on
being same.
one
So,
aspect.
so far as Allahabad is
That so you agree with Mr. Potash Trivedi on this only one aspect.
completely disagree, Milords.
That, no, you said you also said that you agree only.
disagree, Milords.
No, you said you also said that you agree that the potash will be only.
No, I'm not saying anything.
the
I'm only
recruitment-
saying that in
only for the
Allahabad this
recruitment
problem
year.
doesn't exist. No, I'm not saying anything.
Because
I'm
Allahabad
only
has been
saying that in
regularly,
Allahabad this problem
holding the
doesn't
selection.
exist.
And we are filing the
Because
affidavit
Allahabad
in
has
that
been
Malik Mazhar
regularly
case also.
holding the
We
selection.
have
And
already
we are
clarified,
filing the
it's not
affidavit in
Allahabad
that
High
Malik
Court
Mazhar
or
case
Punjab
also.
and High Court.
Because
We have already
unfortunately, I
clarified,
can
it's not
explain my
Allahabad
position.
High
I
Court
don't know
or
the data
Punjab
of
and
other
High
high
Court
courts.
of
There must be
Unfortunately,
some
I can
problems in
explain
some
my
courts.
position. I don't know the data of other high courts.
You are
There must
saying
be
1
some
year
problems in
roster
some
points.
courts.
Are you also agreeing with that? You are saying 1 year roster points. Say, are you also agreeing to that? That is recruited in 2020, say, 2025, and occupying a roster point which remained unfilled in 2019 or 2018, and occupying a roster point.
So,
which
Milords, your
remained
lordships
unfilled
have,
2019
in
or
such cases,
2018.
taken a view that
So, Milords,
if
your
the roster
lordships have,
system has
in such
broken
cases,
down, taken a view that if the roster
authority
system
concerned, either
has
the High Court or
broken
the
down,
Supreme Court should come to a conclusion
the
that the
authority
roster system is
concerned, either the
broken
High
down.
Court or the
For
Supreme
example,
Court should come
in
to a
Justice
conclusion
Rohit
that the
Rajnath-
roster
Wherever
system
it
is
is broken
broken down.
continuous
For
length of
example,
certificate
in
is
Justice
allowed.
Rohit
That is,
Rajnath, that
wherever it
roster
is
will not
broken down,
apply.
continuous length of
But
certificate
if
is
merely
allowed.
because, Lord,
then
then
one
that
selection
roster will not
happens
apply.
in December
But if
2018
merely
and the
because,
other
Lord,
happens,
Lord,
one
in
selection
February
happens in
2019,
December
one
2018
can't
and
say
the other happens,
that the
Lord, in
rule has
February
broken down.
2019.
It all depends,
one
Lord,
can't
whether your
say
lordships on
that the
facts
rule
can
has
conclude.
broken down. Because
It
of
all
the long
depends,
gap.
Lord, whether your lordships
For
on
example,
facts
was
can
in
conclude.
2000, because of the long gap. For example, was in 2018, 15 SCC 439. In the Allahabad High Court, this problem was 15 SCC 439. Between 2002 in the Allahabad High Court, this problem was there. When there were litigations between 2002 and 2009, when there were litigations because of which. So Lordships will not said that we will not apply the rota system. So Lordships will not said that we will not.
Must have been broken
That's
down.
how a
Apply the
Lordships have
rota
done. I'm
system.
not citing that. The
That
judgments
must have
will
been
not.
broken
That's
down
how
on
a
all
Lordships have
bases.
done. I'm not citing that. Some of the judgments
The
which I
judgments
mentioned in
which
my
are
petition
all
are
bases.
contained in this compilation. Some of the judgments which I
For
mentioned in my
convenience.
petition are
are contained
So
in
that's
this
my submission,
compilation
Manoj. I have cited judgments
for convenience.
also. So that's my
Um,
submission, Manoj. I have cited judgments also. For example, Manoj, in one of the cases which came before your lordships, For example, in Asia resurfacing before your lordships, a direction had been issued by this court. Asia resurfacing, Justice Nariman, a direction had been issued by this court that since the Justice Nariman in criminal petitions of washing, since the interim orders are granted by the High Court and then that matter doesn't come up. Interim orders are granted by the High Court and then that matter doesn't come up. Within 6 months the High Court doesn't decide. The order had been passed by this court that if within 6 months the High Court doesn't decide, the stay will be vacated.
That was rectified.
Yes, so I filed a petition on the. So we have been trying to get these things rectified.
Right.
So I'm only saying, Lord, that trying to
errors are
get
there,
these things
they are
rectified.
found to be corrected.
So I'm only saying, Lord, that
If errors are there, they are found to be
so
corrected.
these things, Lord, that will keep on happening and as a part of the. So these things, Lord, that will keep on happening and as a part of the. That in my humble submission, Lord, is one that on account of the exclusive competence. That in my humble submission, Lord, is one that on account of the exclusive High Court, Lord, its discretion not to be. Constitution has reposed, Lord, in the curbed, at least not curbed, not to be. Curbed, at least not curbed. Second, I submit, Lord, that there is so much divergence, so much variation. Second, I submit, Lord, dynamic, whatever the Lordship will do tomorrow, so much variation. And it is dynamic, whatever the Lordship will do tomorrow, one-to-one will never come across that. This age gap disappearance will never come across. There will be some age gap disappearance will never in which the lawyers will be some exercise their choice of the fact, the manner in which the lawyers reasons, please exercise their choice. At least with some. So for all minimal guidance, please leave it to the High Court, Lord, at least with some. I'm grateful. Minimal guidance, and that's my humble submission. Volume 2 R1 is my main written submission. Volume 2 R1 is my main written submission.
Thank you.
Please, Your Lordships.
Yes.
Your Lordships, I appear for the
Honorable
Please,
High
Your
Court of
Lordships.
Punjab and Haryana.
Yes.
Your Lordships, I appear for the
Honorable High Court of Punjab and
Your
Haryana.
Lordship mentioned.
Yeah.
Would your Lordship just look at Article 312? Lordship mentioned.
Yeah.
Would your Lordship just look at Article 312?
Which provision, Mr. Jyoti?
Of course, All India Judicial Service is the best solution.
Jyoti?
Of course, All India Judicial Service is the best solution.
Given.
Article 312. I'm sorry,
No, I couldn't given for that.
Article 312. I'm sorry.
No,
I
I
don't know
couldn't
whether
even go there.
Supreme Court will be willing, my lords, unless, my lord, we don't know. Just look at this. I don't know whether Supreme Court will be willing, my lords, introduced during emergency. Don't know. Just look at this. It's a very dangerous provision. I'll be filing a PIL. Introduced during emergency. And I'll be filing a PIL, my lords. This is surprising. It's on many basic features are being violated. This is surprising. It's on many basic features are anything in chapter 6 of part 6 of part 11 of the anything in chapter the Council of States has declared 6 of part 11 of the Council. If the Council of States has declared by a resolution supported by not only less than 2/3 of the members present by a resolution supported by not less than 2/3 of the members present and voting so to do. That it Parliament may by law provide for the creation of one or more Parliament may by law provide for including an all India judicial service. All India services number, including an all India judicial service. Note the number, 1976.
1976, yes.
Common to the union and the states, and the subject to other provisions of common this chapter. To the union and the states, and the subject to other provisions of this persons chapter. Appointed to any such service. And the conditions of service of the services known at the commencement to any such service shall be deemed to be services created. The services known at the commencement of this constitution shall be deemed to be services. The All India Judicial Service referred to in clause 1 shall not. The All India Judicial Service referred to in clause 1 shall defined in Article 236. Any post inferior to that. So district judge goes out defined in Article 236 if this happens. So district judge rest remains of chapter 6 if this happens. Now this is the most rest remains objectionable. Now this is the most the law providing for the creation of the All India Judicial Service of the law providing for the creation of the All India Judicial Service of may contain such provisions for the giving effect to the provisions of part 6 as may be necessary. And no such law shall be giving effect to the provisions of this constitution for the purposes. And no such law shall be passed to be an amendment of this constitution for the purposes. Chapter 6. So now you bypass 368. Which has been held to be basic part of the basic feature and independence of judiciary. Which has been held to be basic part of the basic feature. 368 itself is basic feature. That's also bypassed. 368
Resolution
itself
is
is
only of
basic
Rajya
feature
Sabha,
that
which
is
also
required. Of
bypassed.
course, Parliament comes in later on.
Resolution is
Parliament
only
comes
of Rajya Sabha, which is required.
It
Of
has
course,
the
Parliament
bill has
comes
to
in
be by
later
both
on.
the Parliament
By
comes to.
ordinary law, Parliament will make
It
the
has
law,
the
just as the
bill has
law
to be
blows
by
in,
both the houses.
by ordinary law, just as the law blows in. Fortunately, no party had two-thirds vote majority in Rajya Sabha, so that resolution. Fortunately, no party had two-thirds vote majority in Rajya Sabha, so that
So after the
resolution
golden jubilee of that amendment, you want to challenge it. So after the golden jubilee of that amendment, you want to challenge it.
Please, your lordships. Your lordships, I appear for Honorable High Court of Punjab
Yes,
and
sir.
Haryana. Please, your
I
lordships.
filed my
Your lordships,
written
I appear for
submissions,
Honorable High Court of
but
Punjab
before
and
Milos, there are
Haryana.
short submissions.
I filed
before I
my
take your
written
lordships to the
submissions,
But
Milos,
before
I
Milos,
would
there are
like
short
your
submissions.
lordships to
Before
look
I
at
take your
the
lordships to the
rules
submissions.
very quickly. Milos, I would
which
like
Milos
your lordships to
are
look
at
at
page
the
721
rules very quickly.
volume
Which
4A.
Milos are at page
PDF
721,
721 volume 4A.
volume 4A.
PDF 721
Volume 4A.
Your lordships may kindly have page 723. I'm sorry. Your lordships may kindly have page 723. I'm sorry.
723 of what, madam?
Of volume
Volume 4A.
Roman
723
4A.
of what, madam?
Of volume
Volume 4A.
Roman 4A. PDF 721. Milos, it starts at 721. Your lordships may kindly have at page 723. Milos, it starts at 721. Your lordships may kindly have at page
723, Milos, I would like to show
at rule 7. 713.
PDF 723, Milos, I would like to show.
Method of
Rule
appointment.
7. Yes, Milos. So, Milos,
PDF
I'm not reading the
723.
whole thing. Your lordships can
Method
see.
of appointment.
Yes, Milos. So, Milos, I'm not reading the whole thing. Your lordships can see.
Volume 4A मिल गया?
Please, Your Lordship. Your Lordships, I'm not reading the whole rule.
The percentage, Milos,
Please,
is
Your
based on All India
Your
Judges
Lordships, I'm not reading the whole
Association's
rule.
ratio,
The
Milos.
percentage,
At that
Milos,
time,
is
it was based on All India
65%
Judges
by promotion,
Association's 10%
ratio,
by
Milos.
LDCE.
At that time,
and
it was
65% by promotion,
direct
10% by
recruit.
LDCE.
Now, Milos,
and 25%,
of course,
Milos,
we are by
pursuant to the
direct
latest judgment, Milos, we
Now,
are in the
Milos,
process of restoring
we are
25% to the latest judgment,
Milos, to
Milos,
the
we are in the
LDCE.
process of
Then your lordships may
restoring
kindly have
25% Milos to the LDCE.
Seven
Then your lordships may
subsection
kindly
rules,
have
sub-rule 4.
Sub-rule 4.
Seven subsection
These posts
rules,
shall be
sub-rule
filled
4.
in accordance with the
Sub-rule 4.
roster attached.
These posts
as
shall be
annexure
filled in
B.
accordance
I'll
with
be
the
taking your
roster
lordships to that
attached
as annexure
that
B.
your lordships
I'll be
thereafter
taking your
rule
lordships
8
to that
is
roster. Assessment of merit, because
that
arguments
your
were
lordships
raised
thereafter
yesterday
rule 8
that there
is
is no subjective
assessment of merit.
because arguments
Milos,
were
when
raised
for
yesterday
the promotees,
that there is no
when they are
subjective
promoted.
assessment of
So,
merit.
Milos, the rule says
Milos,
for
when
assessing
for
and
the
testing
promotees,
the merit
when they are
and the
promoted.
suitability of
So,
the
Milos,
member
the
of
rule
Punjab
says
Civil
for assessing
Services
and
judicial
testing the
branch
merit
for
and the
promotion under
suitability of the
clauses
member of
sub-rule
Punjab Civil
3 of Rule
Services
7 of these
judicial
rules,
branch,
the High
for
Court may
promotion
hold
under
a written
clauses of
objective
sub-rule
test
of
3 of Rule
75
7 of
marks,
these rules
and
the
Viva
High
voice
Court
of
may hold a
25
written
marks,
objective test
and then
of
take into
75 marks
consideration the
and Viva
ACR.
voice of 25
So, Milos,
marks.
this is the process
And
for
then
them
take into
for the
consideration
limited
the
ACR.
written competitive
So, Milos, this is the
examination.
process for
Rule
them.
9
For
applies,
the
Milos,
limited,
where there is a written examination
competitive
which is much more
examination,
elaborate.
Rule 9
and
applies,
which is for
Milos,
600
where
marks.
there is a written
and
examination
assessment of
which is much
record
more
150
elaborate,
marks
and
which is
Viva
for
is for
600
250
marks.
marks.
And assessment
Then
of
your
record
lordships,
150 marks.
request your
and
lordships
Viva is
to
for
have a look
250
at.
marks.
Then
Rule-
your lordships, I'll request your lordships to have a look at rule.
Merit cum seniority recruit.
Yes, Milos, I'm coming.
There is a written examination.
Yes, Milos,
Rule-
I'm coming. So
Merit
rule
cum
12
seniority
deals with the
recruit.
yes, Milos, I'm coming.
There is a written
And your
examination.
lordships,
Yes,
the
Milos,
rule
I'm
12
So
in
rule
crux
12
says
deals with the
that
seniority.
the seniority
And
after
your
the
lordships, the rule
appointment to the
12
cadre
in crux from
says
all sources
that the
will be
seniority
as per
after the
roster.
appointment to the
That's
cadre
what it says,
from
Milos.
all sources
And so it will be
as per the roster 12
roster.
D.
That's what it says,
12D.
Milos. And
That
so it will be
interstate
as per the
seniority
roster
position
12
of the officers appointed
12
in
D.
the services under Rule
The
7
interstate
shall be
seniority
as
position of
given
the officers
in the
appointed
roster
in the services
annexed.
under Rule
Now-
7 shall be as given in the roster annexed. Now, your lordships also 12 sub rule 2, a person recruited
Your
to the
lordships also
service under
12
clauses
sub rule
A,
2,
B, C
A
by all the
person
sources,
reputed to
three
the service
also
under
clauses
of
A,
Rule
B,
7
C.
shall take his position
By
in
all
the
the
seniority
sources,
list
three
as shown in the roster
of Rule
attached
7
as
shall
Annexure
take his
B,
position in the
irrespective
seniority
of the
list
date as
on
shown
which
in
he
the
is
roster
actually
attached as
joining
Annexure
the
B,
service.
irrespective
it's
of
not
the
the
date
date
of
on
appointment,
which
but
he is
it is the
actually
roster.
joining
Now,
the
your lordships may
service.
kindly
So,
have
my
the
lords,
roster.
it's not the date of appointment,
Roster
but
is,
it
my
is the
lords,
roster.
at page
Now, your
730.
lordships may
Introduced
kindly have the
when?
roster.
My lords,
Roster
these
is, my
rules,
lords,
my
at
lords,
page
have-
730.
It has been introduced when?
They have been amended
My lords,
various
these
times though,
rules, my lords,
your
have
lordships,
been-
but the rules are of
of 2007.
They have been amended various times
Rules are of
though,
2007,
your lordships,
but
but
when
the
this
rules
rule
are
was-
of
Roster is, my lords,
2007.
after the All India Judges
Rules are of
Association's
2007,
second
when
case,
this
my
rule
lords.
was-
Roster is, my lords,
This
after
roster
the All
system
India
has been
Judges
introduced when?
Association's second case, my lords. 2007, my lords.
This roster system has been introduced when?
Now-
2024.
2007, my lords.
2024.
Rule 12 has been substituted by notification number
Now-
24. Dated 19th of
24.
August. Rule 12 has been substituted by notification number so and so. The footnote, dated 19th of August 2024.
No, no.
The footnote. At least
My lords, Rule 12 was amended,
Post the judgment.
substituted, yeah. At least
Yes,
my lords,
my lords,
Rule
post the
12 was
judgment.
amended and
Post
that
the
is why it
judgment.
says
substituted,
2024.
yeah.
Only
Yes,
rule,
Lords, 12.
post the judgment.
The rules have been there
And
with
that
effect
is why
from
it says
2024.
Only rule
Now,
12.
your lordships may
The
kindly
rules have been
have
there with
roster.
effect from 2007.
Now, your
My
lordships
lords,
may kindly have roster.
Roster, my lords, is at page 732.
My lords may kindly
And that
have
is under
roster, my
sub-rule
lords, is
4
at
of
page
rule
7.
732.
And that is under
Sub-rule
sub-rule
4 of rule 7.
since 2007 only.
So it has been prior to
732.
2007 only.
Your running page is
732.
732.
That's the PDF page.
Please,
Your
my
running
lords,
page
PDF.
is 722. Running page which you
732.
mentioned,
Page is
that's the
720.
PDF page, 722.
Please, my lords, PDF page. I thought, my lords,
Running page
PDF
which
will
you
be more
mentioned,
convenient
it
for
is
your
720.
lords.
Running pages are there straight away. Why?
I thought, my lords, PDF
I'll
will be
use.
more convenient for
Now,
your
your
lords.
lordships may
Running
see,
pages are there straight away. Why?
Please,
there
your
are
lords,
first
I'll
3
use. Points
Now,
on the
your lordships may
roster.
see which go to promotees.
There
There are first 3
The
points
fourth on the roster,
goes to the direct which go to
recruits.
promotees. Then again 3
The
points.
fourth point
Wave
goes to the
5,
direct
6, 7
recruits.
go to the
Then
promotees.
again 3 points
8 goes to the direct
wave
recruit.
5, 6, 7
Then Milos
go
9,
to the
10, 11.
promotees.
And
8
Milos
goes to the direct recruit.
then Milos 9, 10,
Goes
11.
through the limited
and Milos,
competitive examination.
That is because of the 10%.
Goes
Yes,
through
ma'am.
the because of the weighted competitive examination. Because
That is
65%
because of the
promotees are
10%
there.
reserve.
Yes,
So they have,
because of the
that's why
weightage.
the roster starts
Because,
with them. 65%
and Milos only
promotees are
10%
there.
limited
So they have,
departmental
that's why the
examination
roster
are there.
starts with
This will have
them.
to be changed now.
And Milos only 10%
This will now be
limited
changed because your
departmental
lordships have
examination
restored
are
it to
there.
This will have to be
25%.
changed now.
Now, your
This will
lordships,
now
so
be
these
changed
are
because
the
your
rules
lordships have
and this
restored
is
it
the
to
roster.
25%.
And so, Milos,
Now, your lordship,
so these are the rules and this
after
is
the
the roster.
additional district judges
And
are
so,
appointed
Milos,
by
after
various
the-
three sources.
after the
My
additional
submission is
district
that
judges
they
are
lose their
appointed
birthmark
they
by
become
various
one
three
cadre,
sources.
and their
My submission
seniority
is that they lose
is
their
decided
birthmark.
by the
They
roster.
become one cadre.
I would humbly submit,
and their
Milos, that the
seniority
roster has worked
is
for us.
decided by the
Now, your
roster.
lordships, I will show the
I
data.
would humbly submit,
Now,
Milos,
your
that the
lordships may
roster has
see,
worked
and
for
Milos,
us.
the
Now, your lordships, I
apprehension
will
of
show the
the
learned amicus
Now, your lordships may
that
see,
promotees
and
are
Milos,
lagging
the
behind,
apprehension
both in
of the
terms
learned
of
amicus
designation,
that
elevation,
promotees are lagging behind
and age,
both in
doesn't
terms of
hold true, Milos,
designation,
in our High Court.
elevation,
So, Milos, I will
and
show the
age
data. My
doesn't
submissions,
hold
Milos,
true, Milos.
My
in
written
our High
submissions
Court.
are there,
So, Milos,
Milos.
I will show the data.
I'll
my
show two,
submissions,
Milos. I'll
Milos.
show my written
My
submissions.
written
And then
submissions
I'll
are there,
also
Milos.
show my reply
I'll
affidavit.
show two, Milos. I'll show my written submissions, and then I'll also
So,
show my
Milos,
reply affidavit.
Milos,
So, Milos,
Milos,
Madam, you should be correct on record.
please, Milos.
The roster has come into force. Madam, you should be correct on record.
Please, Milos.
After the roster has come into force in relation to an interest seniority dispute. After the original rule is 12 in relation to an interest seniority roster system. The original rule 12.
Milos
does not-
are,
did not
Milos, maybe
contemplate
we are
any
wrong,
roster system.
but our instructions are that the
maybe
Milos
you are wrong.
Milos, maybe we
Please,
are
Milos,
wrong,
your lordships would
but
know
our
better.
instructions are.
Your
that-
lordships would know better,
Are
Milos.
wrong.
Milos, I can't
Please,
contest
your
that.
lordships
I
would know
can't.
better.
Your lordships would know better, Milos.
Based on
Milos, I can't contest
So,
that.
Milos,
I
may
can't.
kindly
There's
see,
not any dispute on facts.
volume
Yes.
2.
Yes.
So, Milos, may kindly see, volume 2, Milos, the written submissions are there. And running
Volume
page
two,
R2, Milos. volume two
the
R2.
written submissions are there.
And page number
And
one.
running
my lords.
page R2, my lords, volume 2 R2.
And page number one, my lords. Your Lordship has it. So your Lordships, first is the issue framed by your Lordships. Your Lordship has it. In your Lordships earlier. So your Lordships, first is the issue framed by your Lordships seniority in your higher judicial services. As to what should be the criteria for determining seniority rules, etc. in the higher judicial services. That I won't bother your Lordships with. Then my lords, I have reproduced the rules, etc. At para 4. That I won't bother your Lordships with. And is the criteria for designation as the district judge. Is the criteria for designation, additional district as the district judge. So your Lordships, from the cadre of thereafter for the ADJs to be promoted and designated as district and session judge. The following criteria has been framed by the designated as district and session judge. The following criteria has been framed by the High Court. Preceding the year of his consideration, at least an officer with good record of service and whose latest preceding the year of is B plus or above, an officer with good record of service and whose latest designation is B plus or above. 3, he has not been assessed C below average during the last 5 years. 3, he has not been assessed C below average. 4, he has not during the last 5 years. Preceding the year during the last 10 years of his tenure. 4, he has not in the superior judicial services doubtful. And during the last 10 years of his awarded by the in the superior not be considered for designation as undergoing punishment awarded by the full court shall not be considered. The zone of consideration shall be 3 times the number of vacancies up to 5. The zone of consideration shall be 3 times then the number of vacancies up to 5. Subject to the minimum of 5, then twice the number of such vacancies, subject to the minimum of additional district and session judge in the consideration zone, be placed before the cases of additional district and session judge in the consideration suitability of the be placed before designation as district and session judge before the suitability of the consideration for designation as now my lords for the interest before placing the same for consideration besides the issue framed by your now my lords for the apprehension of the learned amicus besides the issue framed by your lordships the apprehension of the learned amicus are as expressed in his application designated or elevated are lagging behind the Honorable High Court also or if they are being designated or elevated they reach there very Honorable High Court also. So my lords these are the age that they get is therefore my lords it has been prayed by the learned amicus that para 29 of All India Judges Association where the roster system vis-a-vis weightage of All India was examined and where the recommendation vis-a-vis weightage regarding the weightage was not accepted and what was accepted was roster on regarding the weightage was not accepted and what was accepted gives rise to the lesser disputes on 2 grounds lesser interseniority to less disputes and it gives rise to the lesser disputes lesser interseniority relied the Honorable Court relied upon the earlier judgments relating to other quotas and said that those 40-point the earlier judgments relating to other quotas laws and said that those 40-point rosters have now let us examine laws these are our data in the light of laws now laws let us examine what has been submitted our data so laws may kindly have the running page 11 of my submissions what has been submitted so laws may kindly have the running page 11 of my submissions where I've given a table. If your lordship permits, I'll read para 14 along with the table, which is at page 10 bottom. Permits, I'll read para 14 along page 10 bottom, which is at page 10 bottom. Para 14 starts at page 10 bottom. Your lordships have it? Yes. Yes. So the state of Punjab and Haryana, the apprehension expressed in the state of Punjab and Haryana, the state of Punjab and Haryana, the apprehension expressed in the state of Punjab and Haryana, as the ratio of promotees and direct learned amicus promoted to the post of district and session judges, as the ratio 2:1 and 3:2 promoted to the post of district and session judges, 2:1 and 3:2 vis-a-vis in the states of Punjab and Haryana, promotees versus that the roster system appended in the states of Punjab and Haryana respectively ensures that the roster system appended in the service 75% of the superior judicial ensures that the proportionate opportunity for 75% of further the data in the last 10 years proportionate opportunity for promotion. That the ratio of promotees and direct the data in the last who have been elevated to High Court that is 13:3 13 promotees who have been elevated to High Court and 13:3 in the states of Punjab and Haryana respectively. And 12 detailed breakup of the data in the states of Punjab and Haryana respectively. So your lordships in the table detailed breakup these of the number of the judicial officers. This is total. So your lordships in the table form the ratio these are the number of the judicial officers of 5:1 entering the higher ratio of promotees and direct so promotees are 5:1 entering the higher judicial service and direct recruits. So promotees are 247 in number in Punjab. Similarly in Haryana promotees are 239 while there are 47 similarly in Haryana promotees are Similarly, on the
39,
next,
while
point,
there are
number of the
47
judicial
directives.
officers who form the ratio
Similarly,
of
on the next,
29 is to
point,
15
number
and
of the
31 is
judicial
to
officers who
21
form the
promoted
ratio
to
of
principal
29
district
is to
judges.
15 and
So the,
31 is to 21
learned editors who have
promoted
been
to
promoted
principal
as
district judges.
So
They are 29
learned
from
editors
amongst
who
the
have been
promotees
promoted as
and
district judges.
15 from amongst the
They are
directorates in
29
Punjab.
from amongst the
And
promotees
31
and
from amongst the
15 from amongst
promotees
the
and
directorates in
21 from
Punjab.
amongst the
And
directorates
31
in
from
Haryana.
amongst the promotees.
Then number
and
of judicial
21
officers
from
who
amongst
have
the
been elevated to
directorates
the High
in
Court.
Haryana.
In the last 10
Then number
years
of judicial
are
officers who have
16
been
in total
elevated to
in
the High
Punjab.
Court. Out
In
of
the
which
last
there
10
are
years
13
are
promotees
16
and there
in
are 3
total in
directorates.
Punjab.
In
Out of
Haryana,
which
there are 13 promotees and there are 4 directorates.
In
Now,
Haryana,
Your
there
Lordships,
are 12
I'm not taking Your
promotees
Lordships
and
to,
4
through the
directorates.
Haryana rules
Now,
because
Your
they are
Lordships,
same.
I'm not taking
Now,
Your Lordships to,
Your Lordships through may the
kindly
Haryana
also
rules because
see
they are
my-
same.
I will take,
Now,
request Your Lordships
Your Lordships
to
may kindly
have a look
also
at my
see my-
affidavit.
I will take, request Your Lordships to have a
by
look at my
Honorable High Court of
affidavit.
Punjab and Haryana.
By Honorable High Court of Punjab and Haryana, page, volume 3, Your Lordships. Page, volume 3, Your Lordships.
Volume 3.
Volume 3.
3A.
Volume 3.
3A.
1428. 1428. Actually, we need to go to 1446. Actually, we need to go to. It starts at 14. It starts at 131, Your Lordships. I'm sorry. It starts at 1431. 31, Your Lordships. I'm sorry. It starts at 1431. 31. It's an affidavit of one Mr. Jaspinder Singh. It's an affidavit of one Mr. Jaspinder Singh.
Yes, 1431.
Yes, Miss. Your Lordships, along with this affidavit, we have also annexed the gradation and the Your seniority Lordships, along list with this of affidavit, judges, we have in the also district annexed the judge gradation and the seniority also, list Milos, the ratio of judges judges promoted, which in is the the same which district I have judge taken, cadre, Your Lordships, and to it. also, Milos, So, the Your Lordships ratio of may judges kindly have promoted, page which is the same which I have 1433, taken, and there is a Lordships, to table it. there. So, Your Lordships may kindly have page 1433 in para 5. And there is a table there in para 5, 1433. 1433. May I, Your Lordships?
Running page 1421.
14, Milos, I'm
May I, Your
requesting Your Lordships to have a
Running
look at
page
para 5,
1421.
1433.
Yes.
Milos, I'm, yes, requesting Your Lordships to have a So- look at para 5,
Running page
1433.
Yes.
Yes. Milos,
So-
running page is Milos,
1433 is all right, yes.
yes.
Milos,
Para 5.
running page is Milos,
Deponent is placing
143
on
is all
record
right,
the
yes.
information
Yes.
sought in
Paragraph
paragraph
5
5 of the application.
Deponent is
So
placing
the
on record
gradation
the
seniority
information sought in
list
paragraph
5 of the
judges in the
application.
district judge
So the
cadre.
gradation
I have
seniority
annexed as
list
annexure
judge
R1
of
for
judges in the
Punjab and
district
annexure
judge
R2
for
cadre.
Haryana.
I have annexed
Then
as
the
annexure
ratio Milos, I have
R1
already
for
taken your
Punjab
Lordships
and
through
annexure
in my
R2 for
submissions
Haryana.
is 5:1.
Then the ratio Milos, I have
Total
already
ratio
taken your
of the
Lordships
total
through
in my
appoint-
submissions is
promotees and
5:1.
direct
Total
And then
ratio
Milos, the
of the
average
total
age of
appointees.
judges, promotees and direct
Promoted through the
recruits.
civil judge
And
cadre
then Milos, the
as compared
average
to the
age of
direct
judges
recruits in the
promoted
district
through
judge
the
bar.
civil judge
So
cadre
promoting
as
officers,
compared to the direct
ages,
recruits
average
in
age
the
is
district
46
judge bar.
years.
So
And
promoting
direct recruits
officers,
is 40
the
years.
age is
In Punjab.
average age is 46
And Milos in
years.
Haryana,
And direct
it is
recruits is
43
40
vis-a-vis
years.
1 in Punjab. 43
And
for
Milos in
promotees
Haryana,
and direct
it is
recruits
43
vis-a-vis
41
1.
years.
43
Then Milos
for
promotion
promotees
ratio of
and
promoted
direct
district
recruits
judges and direct
41
recruits
years. Who have been
Then Milos
appointed as
promotion
principal
ratio
district
of promoted
judges,
district judges and
29 is to
direct
15,
recruits
31 is to
who
12.
have been appointed
This I
as
mentioned in
principal
my
district judges.
submissions also.
29
Now,
is to
Milos,
15,
my
31 is to
submissions
12.
are
This I
that
mentioned
my
in my
learned friends, my
submissions
learned
also.
amicus.
Now, Milos, my submissions
prayers
are that my learned
that
friends, my
para
learned
29
amicus
of the All India Judges Association
prayers
that
which,
wherein
wherein
para
laws,
29
the
of the All
Shetty
India
Commission's
Judges
recommendation
Association,
regarding the
which
weightage
wherein
was
laws,
rejected,
the
and roster
Shetty
was
Commission's
accepted,
recommendation
should be
regarding the
modified,
weightage
or
was
in the
rejected,
alternative,
and roster
50
was
is to 50 or
accepted,
1 is to
should
1
be
should
modified.
done. Because
Or
my
in the
submission is
alternative, that
50 is to
once
50 or
Milos,
1 is to
all
1
the
should be
officers
done.
are appointed
Because my
as
submission
additional
is
district
that
judges from
once
these three
Milos,
sources,
all the
then they
officers are
lose their
appointed
birthmark.
as additional
And
district
Milos,
judges from
they-
these three
they
sources,
become one cadre.
then they lose their
And they are
birthmark.
all equal.
And Milos,
so equals should be treated
they
as
become
equal.
one cadre.
And there should not be
And
any
they are
quota
all
provided.
equal.
This
So
submission
equals
is
should be
Milos
treated as
devotes
equal.
the fact,
And there should
that
not be
in
any
my-
quota
in
provided.
the
This
data
submission is Milos
of
devotes
the
the
Honorable High
fact
Court of
that
Punjab
in my-
and Haryana,
in
in
fact,
fact, Milos,
data
promotees
of
are
the
more
Honorable
than
High Court
the
of Punjab
district
and
Haryana.
direct
In
recruits,
fact, Milos,
both in the
promotees
cases
are
of Milos
more than
elevation
the
to the High Court,
district
Honorable High Court,
direct recruits,
and also
both in
Milos
the cases
as
of Milos elevation
having
to the
been
High
Milos
Honorable High Court
designated as
and
district
also
judges.
Milos.
So in
as,
both the
having
issue-
been Milos
on both the counts,
designated
promotees
as
are more.
district judges.
But despite
so in
that,
both
Milos,
the
in law,
both the counts,
Milos, my
promotees
submission
are
is
more. That
but
Roshan
despite
Lal
that,
Tandon,
Milos,
I squarely
in
applies
law,
to my case,
Milos,
and
my
your lordships are
submission
very
is
well aware,
that
I'm not
Roshan Lal
reading it.
Tandon,
I
and so
squarely
Milos,
applies to my
therein
case,
also
and
the
your lordships are
birthmark
very
is
well aware,
lost.
I'm not reading
We are
it.
one- they are
and
all
so
one
Milos,
cadre,
therein
all
also
must be
the
treated
birthmark is
equally.
lost.
The other
They are
judgment
one-
is
they are
Milos,
all
Atul
one
Shukla, I
cadre,
mentioned all
they
these
all
judgments
must
in
be
my
treated
submissions.
equally.
Wherein
The
Milos,
other
the
judgment is Milos,
different age
Atul
of
Shukla, I
superannuation
mentioned all these
was
judgments in my
provided for two
submissions.
sets.
Wherein Milos,
Depending upon the
different
source
age
they
of
came from.
superannuation
So
was
Milos,
provided for
therein
two
also it
sets,
was held that they are all
depending
equal
upon
and
the
they must
source
be
they
treated
came
as
from.
equal.
So Milos, therein also it was held that they are all equal and they must be treated as equal.
Milos, we
Called the, Milos, I'm sorry, I
Milos,
may be
we
wrong, but we called the High Court and the
Milos, we
instructions
called
that
the
we
Milos,
got
I'm
was
sorry, I may
that
be
the
wrong,
roster
but
has
we
been
called the High Court
under Milos,
and the
in
instructions that we
operation
got was
since
2007.
that the roster has been
Milos,
under
subject to
Milos,
correction, these are
in
our
operation
instructions.
since 2007.
Not in Rule 12. it
Milos,
was in
subject to
Rule 7.
correction, these are our instructions. Rule 7. Rule 7.
Not in Rule
Because
12,
Rule
it
7
was in
says
Rule 7.
the seniority will be
Rule
as per
7.
the roster.
Rule
You
7.
are referring
Because
to
Rule
12.
7 says
Rule 12
the seniority
it
has
was
to be as per the
in
roster.
20.
12 was later on amended.
Rule 7.
7 is
Yes,
only
because
pertaining to
12 was
determination
later on
of
amended.
ratio in recruitment only pertaining where most of the determination of
Your Lordship's
ratio
roster
in
is also
recruitment,
there in Rule 7.
where most of the
And seniority, in relation to
Lordship's
seniority.
roster
is also there in Rule 7.
Your Lordship,
You
may
are
I read
right.
the?
And seniority, in relation to
has been
seniority.
amended only in 24.
Your Lordship,
In
may I
12,
read
12 is amended in
May I read
24.
12
Your
has been
Lordship's is
amended
right.
only in 24.
And Milos may kindly have Rule
12,
7
12 is
once
amended
more,
in
Milos.
24.
Your Lordship's is right. And Milos may kindly have Rule 7 once more, Milos. Your Lordships may have 7, sub-rule 1. Your Lordships may have 7, sub-rule 1.
Sub-rule 4, Your Lordships.
These posts shall be filled in accordance
Sub-rule
with.
4, Your Lordship.
It doesn't use the word seniority.
These posts
They
shall be filled in
accordance
accordance
with the
with
roster. It
attached
doesn't
as
use the word
Appendix
seniority.
B.
They
shall
but
be
Milos, our
filled in
instructions
accordance
are
with the
that
roster
after these
attached as
appointments were made
Appendix B.
through But different Milos, our sources, instructions are they that have after been these placed in appointments these were sources, made in this through roster different for the sources, purpose of seniority.
they have
Since
been
placed in
2007.
these sources. So all this in this data, roster Milos, I for have the given purpose of seniority. My instructions,
Since
Milos,
2007.
are that so all this data, this, Milos,
I
this
have given
data is the
my
result
instructions,
of the roster
Milos,
are
system.
that
And so therefore, Milos,
this,
the roster system
this
has proved
data
to be
is the
successful
result of the roster
in the
system.
Honorable High Court of
And so
Punjab and
therefore,
Haryana.
Milos, the roster
And Milos,
system
there
has
is no
proved
such
to be
discrimination
successful in the Honorable
both
High
in
Court of
terms of
Punjab and
age
Haryana.
or designation
And Milos,
as
there is no
district
such
judges or
discrimination.
Milos,
Both in terms
elevation
of
to the
age
High
or
Court.
designation as district judges
And
or
Your
Milos,
Lordships, the elevation
there
to
is
the
one more
High Court.
chart which I would like Your Lordships to
And
see.
Your Lordships, the
There is one more chart which I would like Your Lordships to see. Basket. This is Milos in the last 10 years. We also wanted to test it, Milos. This is Milos in the
independently, so
last
we
10 years. We
called
also
for
wanted
this
to test
in
it,
the
Milos.
last 10 years, Milos.
Independently,
This is
so
the
we
data for
called
with
for
effect
this
from 15
in the
to
last 10 years, Milos.
2025.
This is the data for with effect from 15 to to 2025.
Of elevation,
Please, Milos. Of elevation.
of elevation.
Please, Milos. To the High Court. Of elevation. Total judicial officers elevated as honorable judges, 16. Total judicial officers 13 promoted as honorable Punjab and 3 directly. 16. And average age on elevation was Punjab officers 57 years. And average age on elevation was promoting officers. Because I would say, Milos, and direct recruits 55 years. Milos, I would say, Milos, 1/1/2000. Can't be exact. From 1/1/2015. Milos, this is up to 1/1/2000. From 1/1/2015 till date.
In 10 years would be 16. So in 10 years. would be
13 plus 3,
16,
16, my lords. Only 16.
No, I think in the last.
13 plus 3,
parliament,
16. My lords, in between there
only
was
16.
COVID years
No,
also.
I think in the last parliament.
My lords, 3 years in between there was COVID years also. 3 years were COVID years. My lords, 3 years were COVID years.
10 years.
3 years of COVID years.
3 years were COVID years.
Can't be only 32 in 10 years.
No, High Court judges.
Sanctions in that is Punjab, Haryana.
My lords, I have.
High Court judges. 94 is Punjab, Haryana.
My lords, I have. There was no appointment.
1/3, so 30.
In 2020, there was no appointment. Because in 2000,
Average.
because in 2000, 2020 and in 2022, during the COVID years, there were no appointments and in 2022. During the COVID years, there were no appointments.
And Milos, may
under either
kindly
of the
see the
courts.
last thing, the average age is 57 vis-à-vis 55.
And Milos, may kindly
In
see the last thing,
Pramoti
the
and
average
direct
age
recruits
is
in Punjab.
57 vis-à-vis 55.
And Haryana, it is
In
57 and
Pramoti and
56.
direct recruits in Punjab. And Haryana, it is 57
So,
and
Your Lordships,
56.
with this, Milos, I end Milos by saying, Milos, that as
So, Your
far as
Lordships,
Punjab,
with this,
Haryana
Milos,
and Haryana
I
High Court
end
is
Milos
concerned, by
the
saying,
roster
Milos,
has
that
worked,
as far as
and
Punjab,
Milos,
Haryana and
the
Haryana High Court is
apprehensions
concerned,
of the learned
roster has
amicus
worked,
Milos are,
and Milos
have no basis.
the apprehensions
Oblige.
of the learned amicus Milos are
have no basis. Oblige.
Best argument should have been. The best argument should have been. The
May please, your lordships. Lordship, to put in a nutshell, may please, your lordships. I appear for. Lordship, to put in a nutshell, IA 251959 F25. Direct recruitees in 251959 F25. They are direct, some direct recruitees from Kerala. And IA 270501 of 25, some direct recruitees and IA 270501 of 25, some direct recruitees from Bihar.
Yes.
On behalf of these direct recruitees, my lord, my humble submission would be, on behalf of these direct recruitees, to disturb my humble on an all India basis, the rules that are necessary to disturb. That would be my all India basis. There is no requirement of a change of rules. That would be my ultimate submission. There is no requirement of a change of rules. I'll quickly refer to the reasons for which I say this. Right at the beginning, I'll quickly refer to the reasons for which I say this. Right through at the beginning, my lord, I would like your lordships to see. We have accepted that lateral induction in the Indian judiciary. We have members of the bar at that lateral induction required and necessary. Members of the bar at higher levels. I would request that we do not look at it, my lord, from the point of view of some individuals. I would request that we do not look at it, my lord, from the point of view of maybe we'll have to look at individuals who have been denied of the health of the system. That will be the proper way to look at it. Not a trade union type of an approach where that will be the proper way to I did not get it. Not a trade union type of an approach where each person says I did not get it, I will not get it. As the point should be what would contribute to the health of the system. For which I would like to bring to your lordship's notice. Observations for which I would like to bring to your lordship's notice. The advantage of having members from the bar recruited at higher levels. The advantage of having can I take your lordship to the bar recruited at higher levels is recognized. 2027 SCC 401 para 29 to 2027 SCC 401 para 29 85 and 87 would be the relevance.
5B.
Giving
5B. 5B. Not into B2. B2. There's no B. 5B. Not into B2. There's no B. B नहीं है A and R.
R1 volume. Volume 1 is R1. R1 volume. Volume 1 is R1, is it?
Page 140, 140. Page 140, 140.
No more a good law.
No, no, it may not be good law. I'm not trying to,
No more a
trying
good
to
law.
follow anything that is laid down there. No, no, it may not be good law. I'm not trying to lateral induction of members from the bar is relevant as to why lateral induction of members from the bar is relevant.
That is the City Commission itself in
The
2002.
reasons are perhaps stated more
The
clearly
City
here. That's why I
Commission
wanted to
itself
just bring to your
recognizes.
lordship's notice that
reasons are
that
perhaps
aspect more clearly here. That's why I wanted to
The-
just bring to your lordship's notice that para 29. The
Volume, R1.
para
Volume from the
para
correct
29.
volume,
R1.
R1. Please inform the
Nobody disputes that the lateral entry has been provided. Nobody disputes that the lateral efficiency of administration
Right.
has been
That's
provided.
That's what I wanted to point out to your
Enhance
lordship.
efficiency of,
And
and
that-
that
right.
is
That-
found
that's
through
what-
That's what I wanted to point out to your lordship.
also.
That's
And
why I
that-
said
that- that
right
is
from the
found
beginning,
through-
right
through
from the very
2002
early days, decades
also.
earlier. That's why we have accepted this principle of, right from the very early days, decades earlier, we have accepted this principle of. Get on the volume correctly, yes, so that this much of time should not be taken. Get on the volume correctly, yes, so that this much of time should not be taken. Can I go on, my lord? Lordship has got it. Paragraph 29 and 87. Can I read 87 because that should be enough. Paragraph 29 and 87. I would read 87 because that should be enough. 87. The constitution makers, in the opinion of this court, the constitution makers, in the opinion of this court, 29 also similar observations of the, I'll be satisfied by reading to 87. 29 also similar observations of the, I'll be satisfied by reading to 87. The constitution makers.
205.
Para 87.
205.
20?
PDF page 208.
Yes.
20?
PDF page 208.
Yes.
Yes.
The constitution makers, in the opinion of this court, consciously wish that members of the constitution makers, in the opinion of this court, at all the three consciously wish that members of the bar should be considered for appointment. This was because counsel practicing in the law court and this have a direct link with this the people was because who need their practicing in the law, their views about the functioning of the court is a constant dynamic. Similarly, views about the functioning of the court is a constant gained at the bar. Similarly, the judicial branch based on the experience gained at the bar positioned as a professional, the judicial branch advocate as a tripartite relationship one with the professional, an advocate as a tripartite relationship one with the counsel learned in the law has an obligation with her or his client. A counsel learned in the law has an obligation in a fair manner and assist the court. Being members to advance the cause, advocates are also considered to be thought leaders. Being therefore the constitution makers, advocates are also considered to be thought leaders. Every rung of the constitution makers, a component of direct appointment from members of the every rung of the judicial system for these direct appointment from members of the bar. Point that I want to urge before for these reasons it's held.
Read further.
The point that I want to urge before your lordship
Read the next
is,
sentence.
please, my lord.
Read further.
It's held that members of the judicial service of any state cannot claim to be appointed. It's held that members of the cadre of district judges in the quota cannot claim to be appointed for vacancies in the cadre of district judges in the quota year not for appointment from amongst. No doubt. The point is, why,
Therefore, the
that's gone, my lord. There is no doubt about
judgment
it.
on which you
The
should have
point
relied
is,
on ought to have
why,
been therefore, which still holds the field. Best
Right,
judgment
my
on
lord.
which you should
The
have relied on
latest
ought to
one,
have been
why I
2002.
rely on that.
This one is the one which is overruled.
Right, my lord.
Lord,
The latest one,
on the
why I
question
rely on
whether
that,
This
they
one is the
can
one which
gain
is
entry
overruled.
as a direct
overruled on
recruitee.
the question
That is all
whether
that is there. They can gain entry
No
as a direct
doubt.
recruitee.
This
That is
has
all
been
that is there.
that the lateral entry is providing grounded doubt.
Right, only I'm
Efficiency in the administration of justice.
I'm only on
The
that point, my
lateral
lord,
entry is
because
providing grounded to
this
issue
lateral entry
efficiency in the
people should
administration
also
of
be
I'm only on
not
that point, my lord,
frustrated,
because
must be properly
this
looked
lateral
after.
entry people
And that's the
should
point that
also
I'm trying to
be
make
not
before your lordship.
frustrated,
That
must
be properly
the
looked after.
grievance of
And
the
that's the
other
point that I'm
section
trying to make before your
promotees
lordship.
cannot be
That
looked at in
the
isolation.
grievance
For
of
the
the
health of
other
the system is
section
very important,
cannot
that
be
people
looked at in
directly
isolation.
recruited
For the
also
health of
have
the system is very important.
They have also,
that
they are
people
also
directly
have
recruited
career
also
progression,
have
which is
avenues.
Nobody doubts about
They
that.
have also, they are also have
Nobody doubts about
career
that, Prabhuji.
progression, which is
Nobody
excellent.
doubts
Next
about that.
submission would be, if the type of,
Nobody doubts about that. The question is
weightage,
whether
next
this
submission would
the
be,
question
if
is
the
whether
type of,
only their aspirations are
weightage,
whether their aspirations of the question is whether only their
exactly what
aspirations
I'm
are to be
saying,
looked
not the
into.
aspirations
Or
of the
the
other side
aspirations of
alone,
all-
this side also has to be,
There's
exactly
no
what I'm
dispute
saying,
on that
not the
proposition.
aspirations of the other side alone, this side both have to be looked into.
There's no dispute on that proposition. That's what we are saying from the
Very
beginning.
evident, my lord. Both have to be looked into is my, yes.
So that's what we are saying from the beginning, that aspirations of all have to be, we are saying from the beginning that
Right, I will be,
proper perspective.
I will be trying to show before your
Have to be-
lordship. I will be trying to show before your lordship.
proper perspective.
I will be trying to show before your lordship. I will be trying to show before
Neither
your
of five
lordship.
of us, nobody disputes, at least.
Nobody disputes, but my point
Neither of
is,
five of
Then
us.
either
dispute
promoter
that
is not direct recruiter.
we should not.
disputes.
That is, in the
is,
interest
then
of the
either promoter
promotees,
is not
the
direct
interest of the direct recruitees cannot be compromised, is the humble submission that I'm trying to make before you. The interest of the direct recruitees cannot be compromised, is the humble submission that I'm trying to make before you. My lord, the next point that I want to make is, when an integrated cadre is made. My lord, the next point that I want to make is,
sources from
when an
they
integrated
lose their
cadre is
birthmark.
made. Yes. They lose their birthmark.
sources
I
from two
would rely on three
they lose
decisions
their
on this
birthmark.
point, my lord.
Yes.
Roshanlal
lose their
Tandon
birthmark.
versus Union. I'm
I
not going
would
to
rely
take a
on
lot
three
to that.
decisions on this
Roshanlal,
point, my lord.
then
Roshanlal
Roshanlal Tandon versus
and
Union.
the
I'm not going to
seven-judge
take a
bench
lot to
in
that.
the Wing decision.
Roshanlal,
I want your
then
lordship to see that.
Triloki, that
And
is
the
a page,
seven-judge bench in the Wing
paragraph
decision. I want your
93.
lordship to see that.
Volume
That is a
R2, page, paragraph 93,
Same volume, page
volume
230.
R2.
PDF page 230. Same volume, page 230. PDF page 232.
152.
Huh?
152. 152.
93.
97, 86.
Para 93. 93.
97, 86.
Para 93.
Yes.
Yes.
155 is the patient. Yes.
Yes.
155 is the patient.
Para 93, we have done it.
This para,
Para 93, the SCC para 93.
this para,
Para 93,
Is that
the
Punjab
SCC
judgment?
para 93. Yes. Yes.
Sub-classification. Is that Punjab judgment?
Yes. I'm not taking a lordship through all the detailed discussions, my lord.
para 97,
93. I'm not taking a lordship through all the detailed discussions, my lord.
para 97.
93. No, it starts with Nakara, principal is stated. No, it starts with Nakara, principal is stated.
Yes. Okay.
Yes. I invite your lordship's attention to the
Yes.
statement of the law there. Thus, I invite your lordship's attention to the statement of the law there. For the purpose of thus law can be further classified. Which is not similarly situated that the court must follow to determine the validity of subclassification. The test that the court must follow to determine the validity of subclassification. Now there is a classification as district judges, the common cadre. Now there is a classification as what circumstances it can be. The common cadre. Can there be a subclassification? Now the test is whether the class is homogeneous or similarly situated for the purpose of the test law. Whether the class is homogeneous or similarly situated for the purpose of the specific law. The class cannot be. If the answer to A above is in the affirmative, the class cannot be in the negative. The class can be subclassified. My humble submission would be in the negative. The cadre is homogeneous. Similarly, my humble submission would be, and the cadre is homogeneous, similarly situated persons, and
The class
therefore,
can be sub-classified upon the fulfillment of the following standards. The class can be sub-classified upon the fulfillment of the
That is, if the
following
answer
standards.
to the first portion is no, then only that comes. That is, if the answer to the first portion
Difficulty
is
is that the
no,
judgments have to
then
be
only
read
that comes.
as a whole.
It
The
has to be
difficulty is that the judgments have to be read. The
ultimately-
practice here is that one sentence is here and
It
there
has to
are
be
pointed
Melody.
out, not once. The
Ultimately,
practice here is that one sentence
ultimately,
is
the
here and
law
there
is
are
laid down
pointed
by
out.
them in these
Yes,
kinds
so
of
therefore
therefore,
you have to read C also.
ultimately, the
If
law
the
is laid
answer
down by them in
A
these
above
kinds
is
of
in the
therefore.
negative,
C also.
The class
Yes.
can be
If
subclassified.
the answer
submission is it can
above is in the negative,
there
there
class
can be
can
a
be
yardstick of
subclassified.
intelligible
The
differential
submission
further
is it can-
classifying the class, and the
There
yardstick
can be a
must have
yardstick of
normal
intelligible
nexus with the
differential
object to
further
be.
classifying the
Now
class.
here, if it
and
is
the yardstick must
homogeneous
have
and there are
normal
similarly
nexus with the object
situated,
to
there
be.
is no question of
Now
a
here,
further
if it is
classification.
homogeneous and
That's
there
the
are
point that I'm trying
similarly
to urge for
situated,
you.
there is no question.
In this
of a
case,
further
all of them are
classification.
on different
That's the
streams have
point
come
that I'm
into the
trying to
common,
urge for you.
common cadre.
In this
And
case,
having
all of
come
them
to
are
the
from
common
different
cadre,
streams have come
on
into
the
the
basis
common,
of the
common
streams from
cadre,
which they came,
and having come to the
you cannot
common
make a
cadre,
subclassification.
on the basis
After
of the
Sangam, there
streams
is
from which
Ganga.
they came, you cannot make a
Sangam, it is Ganga.
subclassification.
Right.
After Sangam, there it's Ganga. There can't be, after
They,
Sangam, Yamuna.
they cannot be a further classification
The-
of
There can't
homogeneous
be
and similarly
different
situated
Yamuna.
group.
They
They
cannot be a further
classification of homogeneous and similarly situated group is a
into
submission that I
the
make.
delta which comprises of both Brahmaputra and Ganga flows into the delta which comprises of both Brahmaputra and Ganga.
Okay, we are only
So
here.
that's the further
Your
classification.
Lordship, and my point is, when
Okay,
we are only here.
That's
Your
what
Lordship,
Mr.
and my
Acharya also
point is,
argued that once
when
you
the integrated
that's
cadre.
what the birthmark is lost. Acharya also argued that once you
That is very clearly stated in Trilogy also. When they come from two different sources, when they merge into one and the common when they come from two different sources, thereafter your birthmark is lost, and there cannot be a distinction on the basis of thereafter your birthmark is lost, from which we came. There cannot be a distinction on the basis of the source from which we came. The source from which we came, because the argument is they have service on the basis of the source from which they have service in the judiciary, and the argument is they have service further classified. They have service in the judiciary, and therefore they can be distinguished. Lordship, it cannot be because look at the other side. Later on, you cannot say. Lordship, it cannot be because look at the other side. Later on, you cannot say. For every 5 years of practice, you can't say when the integrated cadre comes, you cannot later on contend, just as you can't say when the integrated cadre comes, you cannot later on contend a quota for I came from the judiciary, and the other side can also, or a the ridiculous nature of that argument can be seen. And the other side can also, supposing the member of the bar were to argue, ridiculous nature of that argument can be seen, and therefore 5 years I must get a weightage. Supposing the member of the bar were to argue that I have come from the bar, and therefore 5 years I must get a weightage.
Pensionable services of the High Court. But this court has done that for pensionable services of the High Court, that the judges coming from the bar, they will be entitled to 10 years. The judges additional from the bar getting the pension, they will be entitled to 10 years additional.
Your Lordship is referring to the service in the bar to be counted. That is, Your Lordship is referring to the service in the bar to be counted. That is what the purpose of my humble submission would be when they come from different sources. My humble submission would be one source, integrated cadre. They come from different sources, and thereafter one source, integrated cadre based on similarly situated cadre came from. Thereafter, other considerations can happen based on the birthmark that I was putting the question. Supposing there is a better educational qualification, last time that would be a different situation altogether. Supposing there is a better educational qualification, would only say that it's a different criteria altogether. Not the source from which otherwise would only say that the source from which you came cannot be the not the source from which you came. For distinguishing or discriminating. The source from which you came cannot be the and therefore it would be my distinguishing or discriminating between the two different on the basis and therefore it would be my submission that one has at the bar or the other on the basis or the length of service that one has at the bar or the other to further subclassify them on the basis of their as a judicial officer on the basis of further subclassify them on the basis of their or their. The next question is, I think, source from which they came. The way is already. The next question is, I think, what is the basis for this? Why do they want this to be further? What is the basis for this? Why do they want this to be? There are only two things that are further restrictions or improvements to be made to the rules. There are only two things that are stated. One, there is bunching of direct recruitees at the top, and the second is the age difference. There is bunching of direct recruitees at the the top.
My lord,
and the
bunching
second is the age difference. These are the 2 points on
phenomena
which
My
has
lord,
arisen
bunching
because
is
is a phenomena
making
which
the
has
selections
arisen
promptly.
because of, it's a matter
Not
of the past.
making
After
the
Malik
selections
Masud
promptly.
decision,
That
it's a
cannot be.
matter
We
of the
need only
past.
enforce the law.
After
We need
Malik Masud
only enforce the
decision,
directions in
that
Malik
cannot be.
Masud.
We need only enforce the
Every
law.
year,
We
the
need
selection has to be
only enforce
conducted.
the directions in
And
Malik
every
Masud.
year, everything is
Every
mentioned.
year,
Can I
the
invite your
selection
lordship's
has to be
attention to
conducted.
Malik Masud
And
also?
every
Please.
year, everything is mentioned. Can I invite your lordship's attention to Malik Masud also, please?
Bullet 5A, page number 483, with 5A, day 1, bullet 5A. With 5A, day 1, 483,
5A. 5A.
The lordships are aware of it. I just want to particularly point out there. The lordships are aware of it. I just want to particularly point out there.
5A. Roman 5, capital A. 5A. Roman 5, capital A. PDF page 487, otherwise 483. Page number, PDF page 487, otherwise 483.
Paragraph 7. Paragraph 7. Have a look at paragraph 7. I'll take your lordship to 7A and B. Have a look at paragraph 7. I'll take your lordship to 7A and B. We direct us here under.
487.
We direct us here under.
487.
My lords have got it. Can you see, my lord, that A is with regard to. My lords have got it. Direct recruitees. Can you see, my lord, that A is with regard to direct recruitees. And B is in respect of recruitment from by promotion. 50%. And B is in respect of recruitment from by promotion, 50%. Kindly see, my lord, the number of vacancies is to be ascertained by 31st March in both cases. The number of vacancies is to be ascertained by 31st March in both cases. Dates on which examinations are to be conducted, everything is mentioned, and ultimately the dates on which examinations are to be conducted, everything is mentioned. Orders are to be passed, issue appointment order by 30th September. Orders are to be passed, issue appointment order by 30th September. To point out before your lordship in both cases. Now, this has to be followed. We need only insist that this must be followed. Your lordship no change of the rules this has to be followed. We need only insist human failure regarding compliance with these. No change of the rules is required. Now, if that happens, human failure regarding compliance with these, we will have both categories of people ready for absorption to the common cadre. We will have both categories of people. There will be no bunching as it is now to the common cadre. And now your lordship will go. There will be no bunching as it is now seniority list. You will find number of your lordship will go. Direct recruitees are bunched together. Seniority list. You will find happens number of both in direct recruitees are bunched together. As also in this happens because both in this happens because in Bihar as also in Kerala at the selection do not take place because which malady is not there now. The selection do not take place. If Malik Bazar is which malady, there can be no question of bunching at all. If Malik Bazar is no question of there can be no question of various years being bunched together, and there is no question of all the promoters coming in various years being bunched together, and the direct recruitees or the promoters. So that what my submission before your lordship would be that in the light of Malik, so that what my submission before your lordship would be now that in the light of Malik, in violation of that there is no possibility now bunching together in violation of that, and therefore the possibility that the any promoters will have to wait until the entire list of, and therefore the possibility that the promoters will have to wait until the past, it will not anymore be there. To counter that or to provide against that, it will not anymore be there. To counter that or to provide against that, it is not necessary for us to amend the rules. That is what I will
side of this very principle will be the other side of this very that every high court is obligatory, that in light of the annual examination, go for annual recruitment process, to hold the annual examination of assigning, go for annual recruitment process, for the purpose of necessity of assigning.
That's the next point that I have to
points.
Your Lordship point, so that what I'm saying, we know from the both streams, Your Lordship point, so that what I'm saying, we know from the both streams, we have people selected. Annual feature, appointed
Both
also.
recruitments will never take place together, and because the examination is different.
Annual feature.
Merit cum seniority criteria place together because the examination is different. Merit cum seniority criteria is altogether different than direct recruit. All three direct different selection normally different
From each stream, the persons to be appointed are selected. Right? From each stream, person to be appointed are selected. Now the question is, how do you appoint? From each stream, person to be appointed three persons are selected from one. Now the question is, how do you appoint? Do you appoint all of them together on top? Supposing 3 persons are selected from one. Supposing 5 persons promotees do you appoint all of them together at the top? Supposing 5 persons promotees are selected, do you appoint all of them together at the top? The principle of roster comes so that you may have selected people from various sources. The principle of roster together join. You may have selected people from various sources. That is where the roster becomes together join. I found such a lot of grievances against the roster becomes important. I believe the roster is such a lot of ought to be accepted gratefully because I believe the roster is to prevent is something which ought to be accepted gratefully because one particular what it seeks to prevent is again bunching of selectees from one particular stream for one particular year together. To avoid that, it is referred to as a 40-point roster. I am unable to understand how the 40-point comes. It is referred to as a 40-point roster. I am unable to understand how the 40-point comes.
Was it not essentially meant for the history of introducing representation for was it not essentially provided reservations which were unfortunately being overlooked and ignored, provided reservations which were unfortunately being overlooked.
Whatever may have been the historic reasons that the roster came into existence, here the purpose I reasons that the roster came into existence. Here the purpose I now explained to my lord's decision in All India Judges case, 50% to one, 25% now to one, 25% my lord's decision in All India Judges case, if all the 50% to one, 25% appointed on top, that would work out injustice. If all the 50% together appointed on top, that would work out injustice. And therefore my lord said,
and a promoter comes in December, is appointed in January. What is wrong with the promoter comes in December appointee ranks of that very year? January appointee. What is wrong with
I would say all the appointments are to take place together. Well, if you follow Malik Mazhar, all the appointments are to take place together. If you follow Malik Mazhar, all the appointments are to take place.
You have a ready-made list of LDC. You have a ready-made list of the direct recruits, and you have a ready-made list of LDC all together. You have also a list of the together, and you are to give appointments to them all together. You are entering the cadre together. Place them in bulk. You may be at one place than another. How that will arise. Place them in bulk. Appointments at one place than another points of time. That will arise. Then where is under which law there is a common points of time?
Submission would be after Malik Mazhar, there is no question of appointments being at different points of time. That's why it took a lordship to Malik Mazhar. Malik Mazhar from the date of publication to date of appointment to Malik Mazhar. And therefore, from the date of publication to same date of appointment in the same date. While making that appointment, therefore, appointments will be made on the same date. If it is not followed, while making that for us to enforce that and not change the rules for that. My lord, if it is not followed, it's for us to enforce that and not change the rules for that. With great respect. Now, your lordship, whatever, I don't think the High Court would be interested in violating the. Now, your lordship, whatever, I don't think the High Court would be interested in violating should not persuade us to amend the rules. The possibility of violation should not persuade us to amend the rules. We have issued specific. That's what I'm submitting, Mazhar. Specifying the date on which the appointments we have issued specific. All three lists must be ready on a specifying the date on which the appointments will be made. And for that, the court very gracefully said, don't appoint them, bunch them together. And for that, the court very gracefully said, don't appoint them, bunch them together. That's all that is said. They follow the 40-point roster. That's what I said. The 40-point is that's all that is said. They said the 40-point roster. As of now, 50% to one, 25% to one, 25% to the other. So as of now, 50% to one, 25% to one, 25% to the other. So at worst, at best, it can only be a 4-point roster. It is the answer, not my suggestion. That is what Malik Mazhar says. It is the answer. That is what para 29 of all judges. That is what Malik Mazhar says. That is what para 29 of all judges. I'm not able to understand how the 40-point roster would come in. Because there are only three sources. Two for how the 40-point roster would come in. One for direct only for three sources. Two for promotees. One for direct LDC. One for and therefore there is no question of a 40-point roster. Then the High Court does that 4 plus 4 and therefore there is no question of a 40-point roster. Many of the High Court does that 4 plus 4. According to me, it's only a 4-point roster. Made it 40. And then, your Lordship finds ideally what should, according to me, it's only a 4-point roster. What should happen is, and then, the Lordship finds ideally what should, the first 1, 2, I would suggest what should happen is, the promotees, they having been given the first 1, 2, and therefore there is no chance of people being bunched together to deny the legitimate aspirations of those coming lower. People being bunched together to deny the para 29 aspirations of those coming lower said. Though this is what para 29 which then it spoke of the roster said, does not appear to be very correct. 40-point roster would come only where the constitutional reservation very correct. 40-point roster would come only where the constitutional reservation roster. Here, and in that roster, the purpose of the roster is very evident. Don't bunch people together in one. And in that roster, the purpose of the roster is very evident. Don't bunch people together in one. That is the purpose. Give them this 1 plus 2 plus 1 plus 1. All the assumed difficulties, imbalances that are there will vanish. All the assumed difficulties, imbalances that are there will vanish. It's not necessary to do that now. It's already done. It is vanishing. It's already done. It's being followed. It's not necessary to do that now. Rules and again, it's already done. It's already done. It's being followed. And therefore, what is required is the 40-point roster will now be because there was one 10%, 65% and 25%. Because there was one 10%. Right now, after the last 65% and 25%. All that is required is it has to be right now after the last judgment by this court. All that is required is it has to be and the direct recruitee 4. Promotee 1, promotee 2, LDC 3. For this, is it necessary to amend the rules? Is the question I would. For this, my lords to consider. And my humble submission will be kindly do not do that. It's not request my lords to consider. And my humble submission will be kindly do not do that. It's not necessary at all. Thank you. I'll complete now. No. Your Lordship finds the other aspect will also be urged. I'll complete now. Your Lordship finds the other aspect will also be urged. The question is, today, the fact scenario is very different. The question is, today, direct recruitee 25% also very different. LDC, direct recruitee 25% also these people can get in. LDC, your Lordship, I just want your Lordship to be reminded of that because I just want your Lordship to be reminded of that because I accept what Mrs. Dwivedi submitted on that. Now, your Lordship, I accept what Mrs. Dwivedi submitted on that. Now the next question is, my Lord, from the entry grade district judges. Now the next question is, my Lord, the next from the entry grade selection grade judges and the super when they go to what happens? The next higher. That's the next point. Selection grade and the super time Kerala rules. What happens? That's the next point. From the Lordship kindly have a look at the Kerala entry grade to Kerala rules grade. From the it is only merit. Entry grade to the selection grade. It's only merit. It is only merit. I want to read your Lordship the rules. If at all any rules are to be maintained, identical rules on the Kerala pattern has to be maintained. If at all any rules are to be maintained, it is only rules on the Kerala pattern has to be maintained. Made elsewhere. Rule. It is only. It is what is submitted by the Kerala High Court. 2. It is what is submitted by the Kerala High Court, isn't it? I can read. Yes. Your Lordship, it says, it speaks like this, madam. Appointment to 35% selection grade post in the service. It speaks like this, shall be made appointment to 35% selection grade post in the service from amongst the members of the service with effect on the basis of, now comes it, from amongst the members of the service on the basis of, considered only when merit and ability are equal. Seniority being considered only when merit and ability are equal.
Broadly, seniority only determine the zone of consideration. Rest with the ability and suitability.
Your Lordship, from all the I wanted to read the next line also.
Rest with the ability and suitability.
I wanted to read the next line also. Probationers with 5 years service shall be eligible only for being considered for probationers with 5 years service shall be eligible for being considered to be considered. Forget about where you come from, which stream, all of them are considered.
Mr. Prasanth,
Forget about where you come from, which stream, all of them are eligible.
of seniority cum merit, or seniority cum fitness, or seniority criteria of seniority cum merit, high court has or seniority cum fitness, or seniority cum suitability. Seniority, every high court has merit, then first maybe ability, maybe seniority, maybe selection, maybe promotion, but quota has to be there purely on the basis of merit. Selection, seniority, promotion, only for the quota has to be there identified zone of consideration. Seniority will be only
My humble submission would be, and therefore, the grievance that we are lower in the seniority list is not going to affect your lower in the seniority list. Selection grade is not going to affect your movement upwards. That's what I'm trying to point out. Selection grade, so that your lordship finds, well, how it is being enforced. That's what I'm trying to point out. Clarify that so that your lordship finds on the basis of merit. How it is being enforced, your lordship may clarify under 51A purely on the basis of fundamental duties also. And pursuit of excellence is an axiom under 51A in the light of the fundamental duties we have in Kerala. And therefore, your lordship finds, your lordship wants, in the light of the rules that we have in Kerala, can be directed that strictly this movement from entry district, and it can be directed that to selection grade, this movement from entry district on the basis of merit to selection grade, shall what happens is only on the basis of merit lapses into insignificance. And therefore, what happens you don't have to upset the seniority lapses into insignificance. They would still be on top. You don't have to upset the seniority merit and ability. So that they would still be on top. They have the rules to accommodate something which is already there. There is the need to amend the rules. If they are good, if they are meritorious, they come up. Something which is already there. There are many sources by which they are good, if they are meritorious, they come up. Entry cadre district judge, from the many sources by which they can become to the next higher level. Entry cadre district judge, it is going to be only on merit, and therefore your next higher level selection grade. It is going to be only on merit, and therefore your seniority give you a position in there. And therefore, to give you a position in there, it's not necessary to amend the rules. The same position relating to movement from selection grade to, now the same position relating to movement from selection grade to the next grade also. That is the super time scale. Now, my lord, can I take your lordship through the Kerala rules one? Now, the Kerala High Court. Can I take your lordship through the Kerala affidavit? Please see that affidavit. The Kerala High Court. What is the position in Kerala? Affidavit. Is it necessary to invoke the 142 powers? What is the position in Kerala? That is happening in Kerala? Is it necessary to invoke the 142 powers to interfere with something that is happening in Kerala? Yeah.
As my learned brother pointed out, that we are not considering state-wise position.
Yeah.
As my learned brother pointed out, that we are not considering state-wise.
No, I want to point out that if no amendment to the rules is required, the rules I want to point out that if no amendment to the rules is required, the rules presently to other places is what my humble submission would be. If at all your lordship feels it is necessary, an amendment to the rule to provide my humble submission would be. Amendment to the rule to provide weightage, an amendment to the rule to provide quota, and amendment to the rule to provide weightage are not necessary at all, because the malady which we are trying to cure are not necessary at all, because the malady which we are trying to cure, the solution is already there. Now, my lord, if your lordship feels that such a clarification will be given so far as the others are concerned, my lord, if your lordship feels that such a clarification will be given so far as the others are concerned, please do that. The seniority shall be on the basis of the order of appointment. Now, the seniority shall be on the basis of the order of appointment. The order of appointment and now thereafter, according to promotion from there will be roster, not on the basis of now thereafter at all. The promotion from there will be, and if not on the basis of the seniority at all. No, we don't want to promote somebody who is not meritorious and go to the selection grade. Grievance. We don't want to promote somebody who is not meritorious and go to the selection grade. Only the want of those who are meritorious must go in. Excuse to go up the ladder. Because the lordship merit cannot be used as an entry cadre to go up the ladder. District judges, because the lordship finds what will happen is all of them, promoted district judges, the lordship finds what will happen they are people who have not qualified for, they have not come for direct recruitee. They are people who have not qualified for, who have not succeeded in come for direct recruitee as per the last decision. They are people who have not succeeded in who have not got into the for them selection grade. For them who have not got their interest into please don't think selection grade. For them, it's not necessary at all. Please don't think of an amendment to the rule.
Thank you.
It's not necessary at all. I just wanted your lordship to see the Kerala situation as reported by the High Court. I just wanted your lordship to see the Kerala situation paragraph 7 of the Kerala High Court. Lordship, kindly see paragraph 7 of the Kerala High Court's affidavit.
I read out the affidavit. He has read out the affidavit. He has already pointed that out.
What is of importance is, my lord, the statistics given there shows, out of 30, what is of importance is, my lord, the statistics given there shows, out of 30,
That was read to us yesterday by Mr. Giri.
yes, right, I just want to bring it to your lordship notice again so that it stays with your lordship, because it is important so far as the Kerala rules are concerned, they do not result in, it is important so far as the Kerala rules are concerned, they do not result in, that is what I want to point out, the apprehension which are aired by the amicus. That is what I want to point out.
That is already pointed out to a bus by the
High Court,
senior counsel.
unfortunately, did not take a specific stand as to whether this should be there or that should be there.
Rightly, because the High Court
Unfortunately, did not take a
can't,
specific stand as to whether this should be there or that should be there.
rightly, because the High Court can't,
What is just and fair, the High Court will have the guts to,
What is the High Court pointed out by the
just and fair, the High Court will have the guts to, I will
How
not
could the High Court afford to take a
say
particular
that, but it is up to the High Court to take a stand on what is fair and just. I will not say that. We can't avoid that. We can't avoid the responsibility. Fair and just. For the High Court to point out to the court as they have done in this, we can't avoid the responsibility. And show that the High Court to point out to the court as they have done in this are non-existent in Kerala. That the apprehension of the amicus are non-existent in Kerala. That is what I wanted to point out.
Thank you,
application, though my sequence is in the end, my lord, I may be also.
So,
I'm also
in one
the
eye
same
only
application, though my sequence is in the end,
can
my
argue.
lord, I
So
may
your
be
name
also.
in one eye only one counsel can argue. So your name is there in some other eye.
It is the same application.
So insofar as one application is concerned, only one senior counsel can argue. Insofar as one application is concerned, only one senior counsel can argue. Your presence is marked.
What has happened is, my lord, there were 7 applicants. I
What
continue
your
with
presence
4.
is marked.
3 have gone to others. What has happened is, my
That's
lord,
the
there were
reason I
7
said
applicants. That's why he is coming
continue
in.
with 4.
7 applicants originally. That's why he is coming in. 7 applicants originally.
You're not having for anybody from Punjab area. So South has been. So South has been.
I am appearing in IA number
Yes,
260414. I am appearing in IA number for the direct recruits 414 of 2025. For the direct recruits, 3 or 4 submissions to make. I adopt what has already.
You have also shifted
I have
venue.
3 or 4 submissions to make. I adopt what has already.
You have also shifted venue.
The by the time I had already appeared for Delhi, so I could not appear. By the time the Punjab, I had already appeared for Delhi, so I could not. I am going to submit. I am adopting what Mr. Devedi said. But what has been argued, I am going to submit. But I have 2 or 3 what Mr. Devedi said. Particular submissions to make. What has been argued. One argument. But I have 2 or 3 weightage of any submissions to make is necessary. One argument address whether weightage second of any on the roster system, which according to me is a very good system. Second, it has not failed on the roster system, it has not been given a chance to operate properly. It has not failed, but it has not been given a chance to operate properly, which cannot be granted. And my third submission is going to be refer to 2 paragraphs. The quota. But before I come to that, much has been said. I just want my written submission. Paragraphs. Just but before I come to that, show that Delhi actually presents the other end of the spectrum. Just 2-3 paragraphs to show that Delhi actually presents the other end of the spectrum. It is volume as which the learned amicus pointed to your lordships. It is volume 1 to 19. R1, page 1 to 9. 1 to 19.
Dominated by promoting. Certain states, High Court, is dominated by promoting. Then some rationalization would be in your benefit. Is dominated by direct.
My submission is going to be, my lord, that the 2002 judgment in para 30. While rejecting the argument of weightage, introduced a concept of roster. While rejecting the argument of weightage is introduced by saying roster will take care of it. And now, unfortunately, in the working of the roster, there have been 1 or 2 problems. And now, the main problem in the working of the roster, there have been 1 or 2 problems of the direct recruits. The main problem is on account of the delay in the selection process of the direct recruits. This roster, on account of the delay in the selection process of the direct recruits, because this roster then happens and what has been falling from your lordships is promoting comes in what then happens and what has been falling from your lordships is promoting comes in say year 2007. It is completed in 2009. Process of direct recruitment. By the time the direct recruit comes, and then makes it is completed in 2009. I should be given a by the time the direct from 2007, and then makes it perhaps becomes a little too late in the day for it to be granted. And then your perhaps becomes a little too late in the day in favor for it to be granted. And then this is what happened. Judgments have also leaned in favor of length. The two earlier judgments. This is what happened. Even though the rules had rota quota in BS, but because of delay in direct earlier judgments, the court ultimately said no, let it be length of service. But because of delay in direct recruitment, the court ultimately said no, let 5 minutes before that. Please have this volume 2 R1 page. 5 minutes before that. Please have kindly have volume 2 R1 page. Internal page will be 1 to 19 and running page will kindly have first. There is internal page there is a para 6 and running page will be 4. There is a factual position in Delhi. Just 2-3 paras. I'm not going to dwell much on. The factual position in Delhi is just 2-3 paras. Far outnumber the direct recruits. The factual position in Delhi is that since out of 12 numbers the direct district judges, in the post 9 were promotees and 2 were direct. Since out of 12, please turn over the next district page, 9 were promotees and first column is direct and then please turn over the next page. There are 4 direct. First column is direct and then 7 promotees. So and if your lordship will go down the chart in January 25, 7 no direct and if your lordship will go down the chart in January 25 and 9 there was no direct principal district judge 7 and now the factual position in Delhi is also promotees. During the period 20-25, the 17 judges from the district judiciary were elevated to the Honorable High Court of Delhi, out of which 17 were from the district judiciary were elevated to the Honorable High Court of Delhi, then out of which 15 were the situation in some other state also remains the same. Of course, then your lordship has a much better chart given by the amicus, also remains the same, which Mr. Dwivedi read. Your lordship has a much better chart given by the amicus. He has given that Mr. Dwivedi read. Now, those 13 states, I don't need so far as age is concerned, also, given that if your lordship will come to page 6 para, as so far as age is concerned, running page 6 para, if your lordship will come to page 6 para, the factual position is that the average running page at the time of appointment as district judges for both promotees and direct recruits is similar. Age at the average age of appointment as district judges for both promotees and direct recruits is similar. Is in the range of the average age of appointment. There are instances of promotees being appointed even before the age of 35. There are instances of promotees being appointed even before the age of 35. There are numerous instances of promotees who were 34 years and plus between 35 to 38. There are numerous instances of promotees becoming district judges between 35 to 38. So age also is the same in Delhi. Average age is 40 not read the whole of it. 40.6. So age also is the same in Delhi. Average age is 40 versus 40. And I have that chart. So I will give it to your lordship's negative by 6 months only. Now we have said in some other states also the position remains the same. But your lordship may take. So far as now we have said in some other states also actually are taking a larger share both at the stage of as Delhi is concerned and also at the stage of High Court. Are taking a larger share. One other point which I want to point out and also at the stage of High Court because this will then. In the course of arguments, I will be referring to these facts. Page 16 running, page 14 internal, para 28. In fact, if I can start from page 13 internal. Para 27, that fresh para, last 3 lines at the bottom. It is submitted that whereas appointment of direct recruits against vacancies for a particular year is delayed due to administrative process, on an average, the process takes 2 to 4 years. However, promotees are appointed speedily upon arising of vacancies. Now, here that roster will come, and what my lords were, Justice Surya Kant had also observed, that will it be yearly? Why should they get the slots? There are rational answers to that, my lord. I will attempt to give them to your lordships just after I finish reading this. Now, promotees are appointed speedily. As a result, between the period from arising of vacancies and initiation of the recruitment process for direct recruits to the eventual appointment of the direct recruits, several batches of promotees get appointed. In such situation, the application of the rule for determining seniority from date of appointment works in a matter which is grossly unjust and unfair to the direct recruits. Now, we have given instances, my lord, the recruitment notice of Delhi, which was issued in December 13, the left-hand side column, final result is declared in July 15, and direct recruit is appointed in September. In the meantime, in the year 13 itself, 52 promotees came and joined. This is page 14 internal, my lord, in the chart.
Yes.
Yes. Now, similar is the position every year. Now, in the 15 recruitment, the result is declared in 17 and the direct recruits come in May 2018. And during this time, 47 officers are promoted from 16-17. And then, my lord, in 17 again, direct recruitment, final result is issued in 2020 and direct recruits are appointed in 21 and 87 officers are promoted during this period from 17 to 20. So that is one problem. Now, my lord, in my respectful submission, this problem can be solved if there is proper and honest implementation of the roster system. Now, one of the most important requirements of the roster to operate is a yearly recruitment of 3 sources. If there is no yearly recruitment of 3 sources, then the implementation of the roster is bound to cause practical difficulties and problems. Therefore, in Malik Mazhar, your lordships had actually laid down a time schedule as to when the recruitment is to be made. And if that time schedule is adhered to and the recruitment is made in all sources, from all sources within the year, then in my respectful submission, the roster will operate and the roster will fully satisfy the aspirations of all the 3 batches. Now, 2 or 3 more things. First, your lordship said, how would the roster operate? Since the percentages for direct recruitment, promotees and merit promotees is to be worked out on cadre strength, the roster has to operate on cadre strength and cannot operate on vacancies. This is clearly stated in para 29 of the 2002 judgment. It is also clearly stated in Sabharwal, on which para 29 relies on. I have only half an hour, Lord. I will put all this in a small note, and because this is over yesterday, I have improved a lot of things. So the roster firstly has to operate on posts. Now, Sabharwal says that when you start the roster, you start, every roster says 211, 211, 211. Now, when you start the roster, initially, obviously, the entire cadre is available to you, and then you start and you proceed. Now, the second point is, why should the persons be fitted at the roster point, at the slots? That is very important, because once you fit the persons at the slots assigned to each category, every category will then get a representation in every 4 slots in the cadre. There will be no bunching. You will have 2 promotees, 1 direct, 1 limited in every 4 slots of the cadre at every stage. So therefore, when you then proceed to give any benefit of the service, whether it is a senior scale, a super time scale, or even deployment as a principal district judge, when you sit down to make the zone of consideration, within that zone, every person in every slot will be available. So my respectful submission to your lordships is that the solution which was given in the 2002 judgment, and in states where the roster has operated, there is no disparity. In Delhi, the disparity is because up to today, there is no roster. In fact, in the judgment of B.S. Mathur, your lordships in para 52, which in my written submission I have quoted, categorically said, we are now doing length of service, but from 6 onwards, please bring back the roster. Delhi has still not brought back the roster, even up to today. Even up to today, there is a length of service which is going on, and roster has been only brought back if direct recruit and promotee is appointed on the same day, only then. That is not a solution. It has to be a year-wise running account, which is necessary for a proper settling of the equities of all concerned. Now, my lord, so far as the principle of weightage is concerned, which is being argued before your lordships, there are 3 reasons why I say weightage should not be given today. First is, my lord, your lordships originally, when appointment to the post of additional district judges were made, there were only 2 modes of recruitment. Some did not have direct recruitment. It was either promotion or direct recruitment. The Shetty Commission records some states had 60-40, 75 promotee, 25 direct. Some had 2/3, 1/3. Your lordships then reworked those quotas to give a 25%, and I'm borrowing the words from the 2025 judgment of your lordships, my lord, to give an accelerated promotion within the cadre of the civil judges. So that accelerated promotion was given by carving out this 25% limited departmental quota so that they could work, so that they could proceed in a slightly faster fashion. This is a facet of weightage which has already been given to them within the cadre. The man who would have to wait has one option of accelerated LCD and proceed further. Second, now this argument becomes all the more important because now your lordships have given within the junior to senior also an LCD. So now, actually speaking, and hypothetically, it may not happen. If at 24 I pass my law, 3 years I wait, 26 I get appointed as a civil judge junior division, then another 3 or 4 years I get promoted. I take the LCD and become a senior division. Then another 4 years I will have to wait. By 34, 35, even within the promotion quota, I could be eligible to become a district judge. So therefore, my lord, this what you have granted, this what your lordships have granted to them now, to move from the lower junior to the senior scale by way of an LCD is also a sort of a weightage or an acceleration which is granted to the brighter of them, as Mr. Dwivedi had put it, that if a person wants to be patient and take the longer route, then it is, of course, each person has his own aspirations and his own thinking. So this is the second thing. The third now, your lordships have also opened the direct recruitment route to the subordinate judges. So therefore, if your lordship sees a subordinate judge who joins, first has an option to go in for direct recruitment. Then he has an option to take the LCD to move faster from the junior to the senior scale. And then he has another LCD to move from the senior to the ADJ scale. So therefore, my lord, now giving them another benefit of weightage, in my respectful submission, is not the solution. This is the second point that I'm making. The third reason for not giving them weightage is that your lordships in the 2002 judgment para 30 have categorically said that weightage should not be granted and roster is the solution. And therefore, my submission on the first point being, roster has not failed actually. Roster has never been given a chance to, actually a fair chance to operate fairly. And for a roster to operate fairly, yearly recruitment is a must. So therefore, if your lordships is giving some directions, then the directions would be that the observations made in Malik Mazhar for yearly recruitment should be scrupulously followed. That is my second submission. Now, my lord, so far as quota is concerned, so far as quota is concerned, my lord, I can do no better than reading paras 44 and 45 of Muhammad Shujat Ali, my lord. If your lordship will just have that judgment, because that is what is ultimately in Khosa, my lord, of Khosa, the Lokinath Khosa, that is volume 5A, if your lordship will have at page 49, Placitum B, C, and D.
That's 21.
But your lordships is coming back at 2 or is it?
No, yesterday only.
Yes, but then there was some circular which confused some of us. That the bench will assemble on Wednesday for the day or something like that. Didn't say for the day, it said bench will assemble, so we thought perhaps.
No, your lordship indicated that only till lunch today you will.
Yes, yesterday only.
Before rising, your lordship.
So can I then get 10 minutes on the next, 10, 15 minutes on the next?
You decide amongst yourself timing.
No, 10 minutes only. I have hardly taken 15 minutes. I got a slot of, only 10 minutes on the next day. Whichever next day your lordship is granted. Tuesday.
5-7 minutes, you can.
Lord, let me get it on the next table, Lord, 10, because.
They will not take 10 minutes, you'll take more.
No,
Yes.
I promise to take 10 with a maximum of 15, Lord.
Yes.
I'll just recapitulate and.
Get Wednesday, Thursday, Friday.
Time will
Saturday,
not
Sunday.
change. Time will not change, Lord. I will not take extra day.
Lot of time to get your ammunitions,
Grateful.
Your Lordship, there's been a fresh IA that has been filed. IA number has still not been given. If the court could allow, because the registrar is.
Maybe defect, find it out.
Okay. Great.
ਵੱਡੇ